Please do.
And subject to what your lordship may say, my lord, I filed an appeal. They filed an appeal day before yesterday. I pray for listing of the matter on Monday.
Subject to who says what?
No, subject to what your lordship may say.
Okay. We have no problem. You get any number of matters listed. We don't have any problem.
Monday, man.
Oh, yes. Whenever you want.
Online.
Yes.
My lord, in respect of item number 17, I have a prayer. There is an additional affidavit. We tried e-filing of the additional affidavit in that case, but due to some difficulty in the website, it could not be done. So, my lord, we have gone for the normal filing. So, my lord, there is a requisition slip. An
Get the
additional affidavit may be called.
We'll get it.
Because, my lord, inadvertently, some of the factual aspects were omitted from the main affidavit.
All right.
So, we are bringing it on record, obliged.
You are in 17.
Yes, my lord, I am appearing for the contempt now.
All right.
May I please your lordship? Lordship, I am on behalf of Deputy SJ R.K. Dev Chaudhary, my lord. My lord, I am for this item number 7, my lord, the hearing list.
Mm.
My lord, in this case, further 2 weeks time may be granted, file additional affidavit, my lord.
All right. Any objection, madam?
No.
Now you want to file additional affidavit. Writ appeal pending since
Yes, my lord,
2018.
Last
It was as per the
Last
judicial order
order.
last passed.
14/3/2023 as per last order.
All right. Leonard, you are representing Mr. Chaudhary.
Yes, my lord.
He represents whom in this case?
Yes.
Respondent one,
Respondent
three,
number
and 6.
1, 2,
Tezpur Central University.
1, 2,
All right.
3, and 6.
Mr. So-and-so associate to Mr. R.K. Dev Chaudhary, SGA. Praise for it is granted. How much time do you want?
6, 7.
Further opportunity of 2 weeks to file the additional affidavit. All right. List up 2 weeks.
May I please, Lordship?
Mm.
Lordship, I'd like to mention on behalf of B. Setri, Lordship, Mr. B. Setri. Lordship, his wife is hospitalized, Lordship. That's why, Lordship, 3 weeks may be.
Which
signed.
matter, madam?
Item number 12, Lordship,
12.
daily list.
You didn't speak, say which number you wanted to be adjourned. Then council MS so-and-so states that arguing council Mr. Chhetri is unwell and a request is made on his behalf to adjourn the matter. The Mr. KL, any objection?
No.
Mr. KL does not object to the prayer. So made list up to 4 weeks. For list for hearing up to 4 weeks.
Most obliged.
May I please, Your Lordship, I beg to make a mention for item number 8 of the daily list, Your Lordship.
Yes.
Lordship, the senior arguing counsel is out of station. If the matter may be adjourned for a week.
Today, Mr. KL has been given relief by Mr. Sarab's associate. Request is made for adjournment on behalf of the respondents council.
May,
List up to 2 weeks.
may I please, Your
I
Lordship?
beg, Your Lord.
My lord, I beg to mention item number 4, 5, and 6.
4, 5, and
All-
6. Should
4,
we
5, and
adjourn the
6.
entire list?
My lord.
You tell Mr. Balagopalan that no, we are not adjourning.
No, my lord, a matter is fixed on the 22nd. Therefore. my
Another
lord, I pray
matter.
that-
Okay.
I pray that this matter also.
It
may
is
be
stated
fixed on the
that
22nd.
identical matter is coming up for consideration on 22nd
My lord,
and a prayer is made to list these writ appeals along with the same
lordship,
ordered accordingly. 22nd
obliged, my
May.
lord,
List on 22nd May.
obliged.
My lord, I beg to mention for listing of a contempt case, my lord, to be come up for disposal as we have paid the amount.
When do you want
Uh,
the matter to be listed?
Yes.
When do you want?
Oh, my lord, 15th May,
15th May.
May.
All right, 15th May.
must oblige.
Mm.
Item number 1 of daily list along with item number 36.
May it please your lordship. My lord, in this case, there has been a confusion. It is the respondent is shown as a state of Assam. It ought to have been, my lord, the NCB. Now,
NCB. NCB council is here.
NCB council.
You are here. Oh,
My lord, the next thing is, my lord, I am legal aid counsel for the amicus curiae for one of the accused. And the paperwork submitted to me is defective, my lord, can't read anything.
just hold on, hold on. There is little doubt in our mind. What is the conviction?
Conviction is
NDPS.
NDPS.
We understand, madam. NCB is there.
Uh,
What is the sentence?
12 years.
12 years. 12 years conviction matters come to division bench.
Yes, 10 years. and-
About 10. All right. Because in Rajasthan, we have a specific cutoff. All only matters of life imprisonment.
It was like that before, after that it was amended.
All right.
4, 5, 6.
So you want adjournment?
No, my lord, I may be given the liberty to correct the respondent by
Uh,
hand and I'll-
Forget it, we'll correct it. You argue the matter. How do you get out of 32A?
My lord,
My lord. My lord, in fact, these are two connected matters, my lord.
Hmm.
One is item number 36, which has come for hearing, because there are two accused persons who have been convicted.
Hmm.
Item number 36 has come for hearing, and
Hmm.
my item, which was filed later, has come for
SOS,
380
suspension of sentence.
suspension of sentence 389. Now, my lord, this is a case, my lord, where the initial interception was done by SSB, Sashastra Simabal.
Hmm.
And then, my lord, it was handed over to the NCB
For investigation.
for investigation, my lord. There is only one witness who has, only PW1 is the only witness who was a member of the raiding team. Out
Okay.
of the member of the raiding team, only one witness was examined, my lord. And that witness in the doc, he said that I don't recognize this to accused person.
Okay.
Rest are all hearsay.
All right. And counsel for the appellant submits that by mistake, he has impleaded state of Assam as a party respondent in this appeal, in the appeal as well as the application for SOS. But the intelligence officer is impleaded. Respondent number 2,
Yes,
name is not shown.
name is intelligence officer is respondent number 2,
Hmm.
but the respondent number 1 ought to have been the narcotics control board.
He thus prays for and is granted a week's time to file amended cause title by impleading Narcotics Control Bureau, which zonal unit,
Guwahati zonal unit.
Guwahati zonal unit as a party respondent in this, in the appeal as well as the application for SOS. Copies of, you have received the copy? Copy of the appeal memo and the judgment be provided to Mr. SCKL, Standing Counsel, NCB, whose name shall henceforth be reflected in the cause list. Re-notify after 2 weeks. 36.
yes, my lord, in 36, my lord, paper book is given, but it's defective, my lord, can't read anything because the right margin is not
Why they have
properly.
listed 36? We have not directed them to list hearing matters here. Should not have been listed. All right. Well, what is the problem, Mr. Counsel?
This paper book is not properly given, my lord. The side margin in right side is not properly given. It has cut the text, my lord.
Make an inspection.
No, my lord, the entire paper book is defective. That.
All right, registry is directed to supply properly printed, properly prepared paper book to learned amicus curiae. Mr. What's your good name,
Yes,
sir?
Mohammed. Okim Mohammed.
So and so. List along with so and so. After 2 weeks.
My lord, subject to your lordship's convenience, my lord. My lord, may I have the liberty to correct by hand the cost?
No, file a fresh amended cost title.
I'm obliged.
That order we have already passed.
I'm obliged.
Item number 2.
May it please your lordship. Your lordship, I have filed this interlocutory application to bring on record the school certificate of the appellant lordship.
You
Yes,
want him to treat it as a juvenile?
Lordship. That your lordship will find annexure 8, page 14.
We'll remand the matter to the trial court to make an inquiry.
Lordship,
That's the only way out.
lordship.
Did you raise this plea in the trial court?
No, lordship. First time it is raised before this honorable court.
Public prosecutor, you are public
Lordship,
prosecutor, madam?
Yes, my lord.
Yes.
I'm additional public prosecutor,
Yes.
lordship, but there is one discrepancy. In 313, paper book is ready in this case, your lordship. In 313 at page 33, he has written his age is recorded as 24 years, my lord.
How does it make any
Lordship, but
difference?
today when they have filed a IA, your lordship,
You want
the
to file a
affidavit-
reply?
lordship, I may be given.
They have mentioned, he has mentioned his age in what document?
313 statement, 24 years.
313 statement.
Yes. Page 33 of the paper book.
Those things can be taken care of by the learned session.
Let the inquiry be, that is a mandatory requirement.
Yes, your
That
lordship.
if
But
a-
today when they
if
have
a
filed a
claim
IA,
of-
your lordship,
Claim of juvenility is raised,
yes.
it has to be inquired into.
Yes.
Lordship.
Can't be thrown out. Then maybe negated by after inquiry,
My lord.
but the inquiry has to be made. So we should direct the trial court to hold an inquiry. IA dispose of trial court to conduct inquiry under section 94 of the Juvenile Justice Act.
A report.
And submit a report before this. honorable-
Yes, we'll pass appropriate order. Don't worry.
Obliged.
Detailed order will be passed.
Obliged.
You got any judgment?
Lordship.
Any judgment in support of your contention?
Lordship,
Abuzar.
yes.
Abuzar Hussain.
All of you who are arguing, appearing on the criminal side,
Lord.
should someday sit and hear the arguments of Mr. Mishra.
Lord.
Probably that will be sufficient training for everyone.
Lordship.
You should be prepared with the judgments.
Yes, Lord, I brought that.
What judgment? What is the
Uh,
proposition?
That it can be raised anytime before any court. and
It's
second-
mandatory to hold inquiry. That is what you
Yes.
want.
Lordship.
Does this judgment say so?
No, it is not there. Lordship.
Then
Abuzar to none.
Section 9.
Carry from there.
In section 9, it is there. Lordship. Hmm.
but that is a different issue in this case. What sentence is to be imposed? This is not the judgment, gentlemen. You have to
Regarding
give us the
inquiry,
judgment
Lordship.
wherein the Honorable Supreme Court held that at any stage when the claim of
Yes,
juvenility
my
is
lord.
raised,
Yes,
Lordship.
the court is required to make an inquiry.
yes.
Bring that judgment
Lordship.
and hand it over to the court master.
Lordship.
No, we will not suspend the sentence. Let the inquiry report come.
Yes.
We'll keep the SOS pending.
Yes.
Inquiry will be concluded in 2 months. And the direction to the IU to cooperate and provide all documents. Because the IU and the prosecution might want to bring in the certificate of the school first study.
But generally the court also take tips in that regard. If the
Let the
inquiry is
prosecution agency help.
Lordship, may I pray that I may be given liberty to submit the certificate.
Yes, you will
copy of this
participate
order,
in the inquiry. You participate in the
Yes, I
inquiry.
will
No
participate.
difficulty, yes.
Lordship. And
Of
I will
course.
submit a certified copy of this order. to
It
the-
will be a bipartite inquiry, yes. You may submit a copy. We'll, in any event, we'll have to send the record back
Yes.
to the trial court. The entire record will be required for the inquiry.
Oh, Lord.
Yes.
Item number 3.
What is this about?
May I please, Your Lordship?
Mhm.
Pursuant to my lord's order dated 4/4/2023,
Yes.
my lord, the authorities have conducted a thorough survey of the land in question. And it was found that, my lord, out of 2 kotha and 10 lesa, that is the total land which was allotted to the writ petitioner. My lord, a part of the land, my lord, measuring 1 kotha 10 lesa was damaged. Accordingly, my lord, the government has already settled, my lord, an alternative plot of land of the equivalent measure, my lord.
My lord, if it is suitable after verification of his.
You take instructions from your client. Mr. Borpuzari has placed on record copy of the communication dated 9/5/2023 issued from the Office of Joint Secretary to the Government of Assam Revenue and DM within bracket Settlement Department, annexing therewith a copy of the order whereby, alternate piece of land has been settled in favor of the respondent. Copy of the report and the settlement order be provided to land counsel representing the respondent who prays for and is granted 4 weeks time to complete his instructions.
I have already provided finance to my lord. I am so obliged.
Yes. Yes, supplementary list now. The other hearing we can't take up because we'll be doing that parted now. Yes.
Item number 17 to 19 of supplementary list.
17, oh, actually, 17.
Because the others are here in the main list. Yes, I'm sorry.
My lord, is there additional? My lord, may I pray, my lord, at least for some more time, because additional affidavit hasn't come. Without which, my lord, it will be very difficult.
You have received a copy?
I have received a copy.
Okay, very well, we'll pass it over. Then
Only
we'll
for some
proceed
time.
with the hearing matter. And then once we are through, maybe we'll take up the matter at 1.
He'll be here.
We'll take up the matter at 1 o'clock.
Item number 20.
Or my lord, may I, my lord, I'm sorry. My lord, we have spare copies, my lord, we have spare copies. If my lord permits,
All right,
even spare copies we may hand over.
come please.
There is no copy.
Mm.
Please.
This affidavit you are disowning or what?
My lord,
The earlier
my
one you filed.
lord, in addition, because my lord, they were relevant facts, which were not there, they were there before my lord, because inadvertently, my lord, there were omissions, and I felt, my lord, because ultimately, my lord, finally, I know my limitations. My lord is the judge, jury, and the executioner. It's between my lord and the contemner. But even then, my lord, at least even to appeal for
All right.
compassion of my lord, I'll have to bring certain relevant facts
All right,
for my
proceed.
lord's consideration.
proceed.
My lord, at least, my lord, to begin with. My lord, in the page 52, the third page itself, fourth page of this additional affidavit, there are a few dates which I would like to mention.
Yes, please.
Page 52, my lord.
Yes.
18th August 22, that is the judgment. Judgment in order of the Honorable High Court in WPC such and such directing that until the special meeting to discuss the no confidence motion against the petitioner is held and the no confidence motion is decided, the petitioner will continue to function as the president of Karimganj Jilla Parishad, discharging its day-to-day functions, but shall not take any major decisions in respect of financial matters. Now, my lord, in this very particular judgment, it was in para 53 that there was a specific direction to the respondent, to the contemner over here, to hold election within a period of 1 month. That is para 53 of the judgment. I will place para 23, I'm sorry, para 23 of the judgment.
Yes.
1 month period was given to hold election. Now, 20th August 22, petitioner wrote 2 even dated letters. Petitioner, that is
Can
one
we
of the
put,
content.
we would like to put one question to you before that. Your client was represented in this court.
Yes, my lord, he was.
So was there a need to communicate the order, sir?
My lord, there was no need. He
Yes.
was
So
alleged.
this
I'll
letter
proceed
is
on that.
absolutely
Yes.
irrelevant.
Yes, my lord. but
Writing
even
of the
then-
letter is irrelevant.
No,
Yes.
no, I'll proceed on the premise that he was aware of the order of the Honorable Court.
Yes.
20th August 22, petitioner wrote 2 even dated letters addressed to the Principal Secretary Panchayat and Rural Development Department, Government of Assam, and the Chief Executive Officer Karimganj Jilla Parishad, stating that pursuant to the judgment and order of the Honorable Guwahati High Court, he assumed the charge of President Karimganj Jilla Parishad in continuance of his office. So, my lord, the contempt petitioner, by writing these 2 letters to the Principal Secretary and the Chief Executive Officer, made it very clear that pursuant to the judgment, he has assumed the charge. Because the language of the judgment was such that the petitioner would be in charge. 26th August 22, Principal Secretary PRD wrote to the Deputy Commissioner Karimganj asking him to take necessary action as per direction of the Honorable High Court. So 26th August, my lord, he gets a special message also from the Principal Secretary that follow the judgment of the Honorable Court. 1st September 22, a note with the approval of District Development Commissioner Karimganj was initiated stating that petitioner assumed the charge of the President Karimganj Jilla Parishad in continuance of his office in terms of the judgment and order dated 18th August 22 of the Honorable Guwahati High Court. In the note, after narrating the background of the case, it was suggested that if authority pleases, the legal opinion of the government advocate may be sought. Then, my lord, on 3rd September 22, Deputy Commissioner Karimganj made an office note. My lord, this is one part which was not before my lord's notice in the earlier affidavit.
And this part will land your client in heavy waters, we'll tell you.
My lord,
This very part will land your client in further heavy waters.
my lord,
There is a phrase in the criminal jurisprudence, marking time. That precisely what he was doing.
my lord,
It's good of you to have brought this on record.
my lord,
That will make our order stronger.
my lord. I read this, my lord. Then I will make an effort at least to persuade my
Yes,
lord
yes,
to
of
take a
course.
interview.
Of
I'll
course,
try.
your
And
client
I'm
has a
sure-
right.
And I'm
Your
sure,
client has a right to be defended, no
Yes,
doubt.
sir. And I'm sure my lord will give her.
Yes.
3rd September, Deputy Commissioner Karimganj made an office note fixing 12th September 22 as the date for the special general meeting and the draft notice for convening the special meeting, wide number such and such, was also prepared for the said purpose. Meeting was fixed after 9 days of the note because necessary time was required to serve requisite notices to all the members of the Karimganj Jilla Parishad. So, my lord, it is within the time given by the Honorable Court, because in para 23, Honorable Court clearly said that within 30 days, you have to take steps for holding a convening meeting in para 23 of the judgment. It is within that period that the petitioner moved from his side. So, my lord, he made a note. I have annexed all this, as well as the draft notice was also prepared for convening the meeting, and because it was to be circulated to all the members. The time was necessary because at least 9 days time was given. It is within, my lord, the 30 days period itself.
All right, sir.
Then, my lord,
Carry on.
7/9/22, the draft notice was also sent to the government advocate because this is the formality in the office they follow
Yes.
for the meeting. Then 8th September, then, my lord, the order came in the writ appeal, namely status quo to be maintained by all sides.
Yes.
Now, my lord, first blush, I confess, my lord, first blush, when I saw the order of status quo, my personal feeling was that the status quo could only be in respect of the office of the Jilla Parishad. Status quo could not be in respect of the subject matter of the writ appeal. This was the first impression of mine also. But, my lord, the sentence by all sides created the difficulty. By all sides. That means, my lord, nobody will move thereafter, altering the subject matter of the writ appeal. So, my lord, it is not that the contender did not move. He did. And, my lord, he did. Within, my lord, Lordship will notice 3rd September, that is 18th August, 3rd September.
Sir, that was for elections. What about forthwith giving charge to the respondent writ petitioner,
Yes,
sir?
my lord,
Don't try to sidetrack the things, please.
I will not. I certainly will not, my lord, before my lord.
Yes.
My lord, the answer is, my lord, it is, my lord, charge, Deputy Commissioner, my lord, the Panchayati Raj Act doesn't provide. He has no role to play there. The petitioner assumed charge straight away. Petitioner assumed charge. The District Development Commissioner also gives a note and says that petitioner has assumed the charge. Now, my lord, the difficulty arises because here Deputy Commissioner has no role to play. The difficulty arises after the writ appeal. After the writ appeal, the respondent wrote a letter to the Principal Secretary, Panchayati Raj, saying that it is she who's the president of the Jilla Parishad. Now, my lord, my senior, my superior, he doesn't do anything about it. So far as my powers are concerned, my lord, my powers are confined to section 72 and 73 of the Panchayati Raj Act.
Yes.
My lord, may appreciate because Chief Executive Officer also could have done something. The mandate of the judgment was such that it is the petitioner, my lord, who had assumed the charge. And petitioner claimed to be in charge.
Yes.
This is what I was informed.
Read the document whereby the petitioner indicated that she had assumed the charge. Where is that communication?
My lord, in the contempt, they have annexed, my lord, the letter of the petitioner.
Yes.
Please, that, page 36. Page 36, my lord, annexure letter of the respondent 4, the lady, to the Principal Secretary. Petitioner, sorry. Petitioner, I'm sorry, my lord. Petitioner. Petitioner writes a letter
Yes.
to the Principal Secretary, Government of Assam.
Yes.
With reference to the subject cited above, this is to inform you that in terms of the Honorable Guwahati High Court Judgment and Order dated 18th August 22 passed in WPC such and such,
Yes.
I assumed the charge of Chairman Karimganj Jilla Parishad as in continuance of my office. And not only this, my lord, the petitioner, thereafter, the District Development Commissioner initiated the office note saying that the petitioner has assumed the charge.
Yes.
So, my lord, to that extent, the position was very clear.
Yes.
The difficulty, my lord, in the administration arose, and there, my lord, the Deputy Commissioner practically, my lord, had no role to play. When, my lord, the respondent 4, the
Yes.
appellant in one of the case, one of the 2 appeals, she wrote a letter to the Principal Secretary, Panchayati Raj Development, saying, I have got order of status quo in my favor,
Mm.
and therefore I will continue.
Mm.
Now, my lord, in this tug of war, apparently, my lord, the Deputy Commissioner, my lord, in fact, practically had no role to play. So far as the scheme of the Panchayati Raj Act is concerned.
Yes. Yes.
So, my lord, therein lies the entire difficulty.
Mm.
And, my lord, because, my lord, had it been, my lord, the expression by all sides,
Mm.
the word all sides not been there, my lord, I would have proceeded on the premise that this order of status quo is only in respect of the
Yes.
office of the president of the Jilla Parishad. And certainly, my lord, I would have proceeded for the election also. But my hands were tied, my lord, even thereafter.
Yes.
So, my lord, therefore, my lord, I will appeal for the compassion of my lord. Lordship will.
Yes, what do you say?
Yes, my lord, I have a submission now.
Yes.
In fact, so far as this letter is concerned,
Hmm.
page 36 of.
Firstly, let us know where is the direction to the deputy commissioner to take any steps for giving you the charge back. Where is the direction?
Yes. my
Read.
lord. Firstly, my lord, your lordship will
It
say-
has this pertinent argument under the scheme of the Panchayat Raj Act. The deputy commissioner has nothing to do with the handing over or taking over of the charge. Where is that? Where is that direction to the deputy commissioner that he would be responsible for handing over the charge? The CEO may be yes of the Zilla Parishad. What does the deputy commissioner have to do with it? Read out from the Panchayat Raj Act. And you yourself say that I have assumed the charge.
Look,
Well, feel happy?
I'll submit on that.
Yeah.
My lord, in fact, my letter is very clear.
Yes.
My lord, what I say that I have.
Is
assumed
there
that-
any prayer in your letter that please take steps for ensuring that I am able to perform the responsibility of a president?
My lord, I'll come to that. My lord, in my letter, what I have said that I have assumed charge in
Yes.
terms of the High Court's direction, my lord.
Yes,
Now, in the contempt application, my lord, para 7, my lord, I have made a categorical statement
yes.
that, my lord, the deputy commissioner and the CEO, my
Mm.
lord, has not allowed me to, my lord, to enter into the office. Now,
What
if
is
your
the date?
lordship sees the, my lord, affidavit, my lord,
What-
filed by the deputy commissioner yesterday, my lord,
Yes.
these are contradictory statements, my lord.
What is the date you mentioned in your contempt
Yes.
that you are not allowed to enter? Let's see your petition, please.
Yes, my lord.
Where did you go?
Your lordship will come to, my lord, my contempt application.
Para?
Yes, para 7, my lord.
Para 7 would be at page number
Yes, para 7, my lord, it is
Yes.
page number
11.
11, my lord. My
Hmm.
lord, may I read it?
Yes.
It is respectfully submitted that despite being aware of the said order dated 8/9/22 passed in so and so of the division bench of this honorable court, the judgment in order dated 18/8/22 passed in WBC so and so, the respondents
They
authority.
allowed the respondent number 4 to act as president and
Yes,
exercise power and function.
yes.
What is the action she has taken in this period?
My lord will kindly see, it is respectfully stated that though legally and in terms of the order of the court.
Oh,
the-
Mr.
My
Counsel,
lord,
we are asking you what acts has the respondent number 4 performed
yes,
during
yes.
this period?
Last page, your lordship will see page 43.
Hmm.
My lord, this is a letter of 19/9. My lord, even after the order of the division bench passed on 8/9.
Hmm.
Now, this is my lord, the lordship will see the letterhead, Bimala Suklavadya, my lord. And she has, my lord, signed this, my lord,
Page
order,
number?
page 43. She has signed this letter as president of.
All
Karimganj
right,
Jilla.
she may do it. She may sign a letter as the chief minister of Assam. What prevents her?
No, 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 my lord, she's acting in the office, your lordship will see what.
What is the, gentlemen, this is a case of you asking the respondent to be punished for willful disobedience. What he has done. One person may assume that she is holding the charge of XYZ post.
Now, lordship.
How
will
would
kind-
the deputy commissioner be responsible?
My lord, this is a-
What is his role, Mr. Counsel? What is the role of the deputy commissioner in this entire?
Your lordship will come to page 38, my lord,
Yes,
of the contempt application.
yes.
My lord, this is the order.
Urgent action was holding elections. What more was wanted from him? The direction to, what was the pertinent direction to the deputy
My
commissioner?
lord will kindly see, with reference to the subject cited above, I am
You
directed. to-
you see,
My lord.
the very fact that you have filed the contempt after the division bench order,
My lord.
that by itself indicates that you are only interested in the election part, not the part of you not being allowed to hold the charge of the president.
My lord,
Why
what-
did you wait? Tell us.
My lord, in fact, in between, my lord, I tried, my lord, to assume the charge.
What
my
is
lord.
it? You say that I have assumed,
No, my lord, in
and,
fact,
and the order says it is deemed.
my lord, my paragraph 7, my lord, is very clear. My lord,
On what date did you go, sir? Tell us. And who prevented you? He was not there in the office. We
My lord,
presume.
I have made a categorical statement. If your lordship sees para
Read,
7.
read para 7. please.
Yes, my lord.
Yes,
Para 7 is very clear.
yes. Read.
The last part, my lord. It is respectfully stated that though legally and in terms of the order of the court, the petitioner is holding the charge of president,
Hmm.
Karimganj Jilla Parishad. the respondents, more particularly the Deputy Commissioner Karimganj. and the
Yes,
Chief
now
Executive are
tell
not
us, sir,
allowing-
tell us
My lord.
how he is responsible for her in assuming or putting up a charade that she is holding the charge.
My lord, in terms of section 72,
Mm.
my lord, Deputy Commissioner is also an official,
Now,
which is, my lord, connected
read-
to my withdrawal, my lord, and removal.
read 70 Panchayati Raj Act, Panchayat Act. Section 72,
72, my lord.
read.
Deputy Commissioner comes into the picture, my lord. A member holding the office as president of the Jila Parishad may resign his office at any time by writing and send it to the government through the Deputy Commissioner.
Mm. All right,
And the Vice
So
President of
he's-
Jila Parishad.
he is a post box, post office.
Yes.
He is a post office. Nothing beyond that.
Now, my lord, here is a case.
Shows from the scheme of the Panchayat Act
My lord.
that he is the person responsible for the taking over of the office of the president. Who is, in what manner that ceremony takes place?
My lord, I am on the sanctity of the order of this honorable court. my lord.
Understood,
What I
sir,
want-
understood. The order says
Yes.
deemed
My lord,
and you
the-
said assumed.
The respondent does not say that he is not aware of the order of this honorable court, my lord.
Gentlemen, what direction has been given to him? What is the pertinent direction given to the respondent?
I'll come to it, my lord. If your lordship comes to 70, my lord, section 70.
Yes. 70.
70.
Mm.
My lord, this is also a provision whereby the Deputy Commissioner, my lord, is also involved
Yes,
in respect of, my lord, the election of the President and Vice President. Deputy Commissioner is also a part of that election, my lord.
so
My lord,
that is at the inception,
Yes.
when the Parishad is constituted,
Right.
he calls the meeting.
Right.
After that, what is his role?
My lord, what I'm trying to say,
Charge, day-to-day affairs.
Yes.
Speak up.
my lord, my humble submission
Gentlemen,
is, my lord, I am
The
also
fact
not,
that you file the contempt subsequently is a very material fact in this case.
my lord, in fact, what I'm trying to say, my lord, since the order of the learned single judge is very, my lord, clear, crystal clear. So in terms of that, my lord, I should be allowed to, my lord, enter into the office.
Who stopped you, sir? We are asking you,
My lord, that is what I'm stated in para 7, my lord.
Oh,
The Deputy
be
Commissioner,
specific. Who stopped you? Who was at the gate of the office?
my lord, the Deputy Commissioner and the Chief Executive Officer, my lord, they restrained me, they did not allow me. to
Read,
enter.
read from the,
But para 7, my lord, I have stated. in the
yes,
context.
what is their reply? Let us see.
Yes, your lordship will come to the reply, my lord. The yesterday's
Affidavit.
affidavit, my lord.
Yes,
They have made it very clear.
Para 7, he has not stated that.
Lordship will
that I have
kindly come
stopped
to
it.
yesterday's.
yes,
affidavit.
stated.
Yes,
More particularly, the Deputy Commissioner Karimganj
my lord.
and CO Karimganj are not allowing
Yes.
or cooperating the petitioner to discharge his official duties.
My lord, we kindly see paragraph 8 of their yesterday's affidavit
Yes,
filed by the Deputy Commissioner, para
Let-
8. my lord.
let us see.
What he has stated there is
Yes, yes.
that while denying the correctness of the statements made in para 7 of the petition, I say that in terms of the first direction of the honorable court dated 18/22, the process of reinstatement of the petitioner as president of Karimganj Jila Parishad, hereafter referred to as a Jila Parishad, for discharging its day-to-day functions without his involvement in any major decision in respect of the financial matters,
Mm.
which was underway, could not be completed as the
Yes.
second direction.
That
of
is
this honorable
basically a
court.
misunderstanding of this court's order. That is a misunderstanding of the court's order. Now today what they have said, let us see. Yes. Read para 7.
Para 7 of today's ballot.
Yes,
That the under Assam Panchayat Act duties and functions of the Deputy Commissioner are limited to forwarding the resignation of the President of the Jila Parishad to the government. Well, these are contradictory, in my.
Para
humble
9.
submission.
Para 9.
Yes. But prior to 8/9/22, the petitioner by his own admission claimed to have assumed the office of the President of Karimganj Jila Parishad. This fact was known to the Principal Secretary Panchayat. Director. Otherwise, the provisions of 1994, the deponent had no power to resolve the contesting claims of the petitioner.
Yes.
And the respondent number.
That is an argument based on law, that even if there is some contradiction, we'll ignore that. Now read the direction, pertinent direction. To whom was that direction given?
Yes.
Or whether there was any such direction to any particular officer to allow him to function. Let us read.
My lord, here, Honorable, my lord, single judge at para 20 had set aside all the letters,
Yes,
including the handing over, my lord, to the respondent 4.
all right.
Yes,
Who handed over the charge?
my lord.
Who handed, where is the handing over order? Where is the order whereby the charge was handed over?
Handed over, my lord, to the respondent 4.
Where is that order?
Yes, that
Letter.
order your lord
Writ
will
appeal.
find in the writ appeal, my lord.
Writ appeal.
Yes, my lord. That order is in the writ appeal. This is at page, my lord, 93. Page 93 of 289/22. Writ appeal number 289 of
Yes, just
22.
hold on.
And I was not there. Oh, no.
93.
My lord, page 93,
Chief Executive Officer.
my lord.
All right, we will ask the Chief Executive Officer then. He has no role to play. Who represents the CEO? Yes. But you never communicated this order to the CEO. Your letters are to the,
I have communicated, your lordship will come to my contempt application, my lord.
yes.
It is at page, this is, I have communicated, my lord. Received. And it is received under seal and signature also, my lord.
Where is it?
Yes, my lord, I am coming to that. Your lordship will come to page, my lord, 37, my lord. This is addressed to the chief executive officer.
37, just hold on.
37, my lord.
Mm. CEO, yes. Who represents the CEO? Or who is the CEO? And the notice of the contempt has been served on CEO also.
Yes, yes.
Why is he not
everybody,
there?
my lord. He is represented, my lord.
He is represented.
Yes, my lord.
Yes, gentlemen. You are for the CEO. The burden seems to have shifted now.
Your lordship, the
First, call your client in the court. Keep the contemptor present. The contemptor, why he is not here? Why you have not filed affidavit on his behalf?
your lordship, there is no such direction to the CEO.
It
Or
is you
any-
who had
any
given the
party.
charge.
If it.
It is you who had given the charge to the respondent number 4. So you can't shun the responsibility.
Your lordship, my learned friend is relying on a document which was issued priority during the pendency of the writ petition, your lordship.
Yes,
Yes, sir.
that is charge handing over. In the scheme of Panchayat Raj Act, the CEO would have all the entire jurisdiction of charge taking over, charge handing over. Keep your client present. Arguments have been heard. Learned counsel, senior counsel, Shri so representing the respondent contemptor, has placed on record an additional affidavit on behalf of such contemptor wherein, unconditional respondent number 1 kar dena, contemptor respondent number 1. Unconditional respondent number 2, wherein, unconditional apology is offered on behalf of such respondent regarding the averments of disobedience of this court's order made in the contempt petition. In addition to the above, it was submitted that in the scheme of the Panchayat Raj Act, the deputy commissioner has no role to play in the process of handing over charge of the president of the Zilla Parishad, handing over or taking over of the charge of the president of the Zilla Parishad. First off, attention of the court is drawn to the letter dated 19/10/2021 issued from the office of the Chief Executive Officer, Karimganj Zilla Parishad, along with which, the joining report of the respondent number 4 was forwarded to the Principal Secretary Government of Assam. First off, since after considering the relevant provisions of the Assam Panchayat Act, to be specific, section 70 and 72 thereof, we are satisfied that we are of the view that the role of Where is the provision pertaining to handing over charge? 77(2). No, who hands over the charge? How does he assume? What is the process? What is the letter? CEO. Page number 54. But that letter, of course, they have pointed out to comply with the directions given. So that was the principal secretary conveying the decision of the government
That is.
to entrust. That is not the issue.
That is.
When once after the election, what we are trying to find out is, once after the election, the president is declared, the vice president is declared. Who is responsible for handing over the charge or giving them the charge of office?
Your act is silent on this aspect.
Act is silent. Okay. Perusal of the above letter and the provisions of the act would reveal that the act is silent on this aspect. In the circumstances noted above, comma, we are by required that at council, Mr. So and so, what's your good name, please?
K Kumar, yes.
K. Kumar, to file an affidavit on behalf of the Chief Executive Officer, respondent number 4 in this contempt petition.
It's not 4, my lord. Chief Executive Officer is 3, my lord.
Respondent number 3, acha, he is 4 in the appeal.
My lord.
Respondent number 3 in this contempt petition. For the next date of hearing, comma, the personal presence of the respondent number 2, Deputy Commissioner, is exempted. Re-notify on
2 weeks time maybe given.
2nd June.
Second one.
Yes. For what? The order of status quo dated so and so shall continue this, record this order in the IE, shall continue till next date. This order of meanwhile, that means till it is not altered, it continues. But you want to limit it? If the order is in the meanwhile and not till a particular date, it clearly indicates that it is till further orders. Why do you want to restrict it?
Oblige.
No need to pass any order in the IE. Yes, next.
May it please the Lordship.
Yes.
Lordship, this is the petition that challenged the APDCL rules for selection of junior managers. Basically, the petition challenges the stipulation of requirement of 60% in diploma examination.
Yes.
This actually happened day before yesterday, Your Lordship. Mr. Goswami is not well. He's advised bed rest. Our basic contention.
The
Your
additional advocate general.
Yes, I'm appearing on behalf of the corporation, Your Lordship.
Yes.
We went through the judgments, Your Lordship. One clear line of judgments which appear is that otherwise the authority has a right to prescribe qualifications.
Are you addressing the court on merits today?
No, Your Lordship. What I am saying, Your Lordship, is that that particular issue which Your Lordship had raised, that can we prescribe qualifications which have the effect of shortlisting candidates before they appear in the written exam? Perhaps that question of law has not been properly, Your Lordship, decided, Your Lordship. It's because we could not find any judgment specifically on that issue. So we have asked for instructions. We'd like to file an affidavit, Your Lordship.
All right, file your affidavit. Then.
Very well, Your Lordship.
Mr. So and so, associate to Mr. P.N. Goswami, additional advocate general, Assam. prays for. Issue notice, so and so appears on behalf of so and so. All respondents you are representing,
Yeah, no, your lordship, only 3 and 4.
appears for the respondents number 3 and 4. What's your good name, sir? N. Das. Mr. N. Das. Government Council appears for the respondents numbers 1 and 2. Only one. So is Deputy Secretary APSC, APSC Council का नाम लिख दीजिएगा. Appears for respondent number 2. Council representing the respondents pay for and are granted 2 weeks time to file additional affidavit on their behalf. Sufficient copies of the writ petition be provided to current council representing the respondents.
Obligation.
List on 2nd June.
Lordship, today is the last day to apply.
Madam, these rules were in force since when?
But Lordship, we filed it. we
Madam, the
became
rules,
eligible.
this is a provision in the rules,
Lordship, if you're.
which are in
excluding-
existence since.
Lordship, Lordship may give
just-
us liberty to at least participate subject to orders of find out.
Madam, just hold on. What we are asking you. Rules were promulgated in which year?
2012.
When did you get your degrees?
2000.
One of them got it in 2011.
11. So ever since 2012, you knew that you will not be able to participate in this process. That gives your
But
answer.
Lordship, the advertisement came on 30th. That is.
Advertisement has to be in accordance with the rules. There is no doubt. You must have argued n number of matters
Yes,
which
Your
says condition in advertisement contrary to the rules
But-
will not be accepted. Did you have any idea in your mind that they would relax it? Not possible.
But
This is a
Lordship,
condition in the rules.
There is Lordship, the reason we've come now is because 30th March is the advertisement which.
Madam, the
says in the
advertisement,
post.
any day it came, had to have this condition. That's
Only
your own-
Lordship, the
that's your
hardship
answer.
is I have a fundamental right to apply, which is taken away by. these
Madam,
rules.
yes, it was taken away by the rules 11 years back. While you were sleeping.
Lordship, but the cause of action arises on the day when the.
No,
advertisement happens.
no. You are agreeing with the rule, not of the advertisement. The challenge is to the rule. The advertisement just complies with the requirement
Lordship
of
will give
rules.
us a short day so that.
Yes, rule list on, but they'll have to file the affidavit. You have a very logical argument. Senior counsel, Mr. Goswami, yes, he did convince us to great extent. But the issue is you are too late in the day. We may give a shorter date because this rule
We'll file it within a week.
on the face of it is not
Yes.
justified apparently. List on 26th May,
Very good.
26th May,
Obligation.
Oblige, your Lordship.
because allowing your clients by an interim order would open a Pandora's box. Then it has to be a general direction to all people without any restriction of percentage minimum qualification. How can it be specific for the petitioners only?
Obligation.
Oblige, your Lordship.
Yes. 26th May.
May I please, your lordship. Lordship, on last occasion, lordship was pleased to direct the
Yes,
state
Mr. Nath.
to obtain the instruction.
Hmm.
But I have received the instructions now.
Yes. You have an order with you?
No.
No. Mr. Basudar is smiling. Is under process. Detention cost illegal, grossly. We give him liberty to sue the state for compensation. Is it not the case? This is a case warranting observations on your authorities.
For that aspect, the Lordship may give us some time.
For what? After directing his release?
No. Release,
Release is automatic, Mr. Nath.
Release is automatic. Lordship is.
We don't even need to pass an order. We just need to observe that beyond 3 months, no one can be detained. And there is no order. Call an advocate general. We'd like to ask him. These are very serious matters. You know, there is a consequence of the order being affirmed that you have right to forfeit his property under section 68F. And you are foregoing that right by this. There must be hundreds of orders of this kind. People may not even be, the other side is, people may not even be having access to the legal assistance. They might be rotting in jails without the confirmation orders. What a callous approach you are. And this is from the political department, almost home department kind of thing.
Yes, yes, home and political.
This is absolute rubbish, we will say.
No, this will be taken care of. This will be taken care of. Henceforth, this will definitely, well, I have already taken.
So Mazumdar, that was about 2 months back.
Thinking, well, the court is serious, the government is also serious, but then officers who are dealing with this matter, they are not very keen.
Then not,
Unless there is a confirmation, everything goes. After 3
man
months.
can't be kept behind bars 22/7. You've got any judgment?
Lordship, so far the judgment is concerned, Lordship, regarding confirmation, I have not brought any judgment. But the rest of the part where I am hammering, Lordship, regarding the furnishing of the document and all. But the Lordship, the section 10 is not compliant.
Detention not confirmed order, the further detention of the petitioner after 3 months is grossly illegal. Hence, the petitioner shall henceforth be released from custody. We'll pass the detailed order and this is ridiculous. Both cases,
Well, in the other case, we have filed the affidavit. Copy I am having.
same situation.
Same. But I.
Call Mr. Saikia, please. We'll like to tell him. Immediately send your officers for training. And coordinate with the NCP. NCP is having a zonal unit. Why don't you approach them for the detentions?
No, well, that's true. That's true. We definitely have to. So this affidavit we are filing, in fact, I have given it for filing. These are copies from my office copy, Kindly see paragraph 3,
Yes, expected to be issued shortly.
Lordship, may I please, Lordship? Lordship, I am having some judgment on this point, Lordship.
Pass it on. Yes. He at least seems to have justified his brief, though the court came to his rescue. Which judgment you are relying on?
The first judgment, Lordship, I am relying on 1972 1 SCC 456.
Yes.
That is Sri Ujjal Mandal.
No.
Paragraph number 8, Lordship.
Yes.
Article 20, may I read it, Lordship?
Yes.
Article 22(4) of the Constitution has specified the maximum limit of initial detention. The detention for a period, then 3 months, can only be made on the basis of report of the board. The Act authorizes a possible detention of more than 3 months. It is because the appropriate government wants to detain a person for more than 3 months that the matter is referred to the board, and it is only when the board makes its report that the appropriate government can fix the period of detention under section 1, subsection 1 of.
Any judgment under PIT and NDPS Act, that situation might not have arisen.
Yes,
There is.
very recent, Lordship. It is there, Lordship, passed in WP Criminal 32 of 2022
Yes.
by a division bench of Honorable Division Bench of Manipur High Court. Paragraph number 12 maybe.
All these states, the same situation is prevailing. Paragraph number
12, Lordship.
12.
The detention order dated 12/29/2022 was valid only for 3 months, and on its expiry, there was no order for extension of the same.
We had
not-
decided one matter. Mr. Mazumdar, what is the number? Give it, please. Do you recollect? Rupam, do you recollect that matter? We'll find out anyhow.
We'll find out, we'll furnish.
We don't need to write 10 pages for this purpose.
Yes.
The one paragraph judgment will serve the purpose. Mr. Nath, your officers were aware. About 2 months back, we decided that matter.
Saru Ahmed.
Whatever I don't remember.
We'll just find out the
I'll-
number.
But if they don't wake up even after that, there'll be 100 more in jail.
In fact,
Today only we'll issue direction in this case only. Mr. Saikia, you need to sack a couple of officers in your political department. They are hands in glove with detainees detained under the NDPS Act.
Yeah, Indira has it at contempt over like that.
2 months back, we decided a case in which Mr. Mazumdar was appearing. You pass an initial order of detention, get a report of the advisory board, don't confirm the order. Very easy. The court notices the defect, releases the detainee. Saap bhi mar gaya, lathi bhi nahi tooti.
Yes, no?
No, it NDPS.
NDPS.
22(7) says no detention beyond 3 months,
Lordship.
unless there is an order of confirmation. In none of your cases, there is an order of confirmation.
We'll take a notice of this lordship and immediately do the rectification.
There has to be some kind of disciplinary action. Because even if it is happening because of
Yes,
ignorance, then it's also very serious. You are dealing with people who are drug peddlers.
Lordship,
They are affecting the society at large.
absolutely. And police is doing a great job now, Lordship, for last 1 year.
You
If
see,
this
this
body-
detention matter, you should advise your officers to leave it to the NCB. They are experts in the field. Your officers are not even having any idea. The NCB officials, I can tell you for the reason that there was a particular period in Rajasthan when almost 80% detention matters were with me. And that time NCB used to detain. Now there even the NCB has stopped doing that. NCB is one agency which is virtually drawing salary for doing nothing. It's a fact. How many recoveries are affected by NCB? Just take note. Maybe 10, 12 in a year, and the entire department is functioning. So they should be more vigilant actually. So maybe you can coordinate the detention part. You can assign it to NCB.
Lordship,
They would make the orders stronger because they are trained in that. Your officials are not trained.
maybe that.
That is the reason.
Lord.
That is the effect of release of these detainees.
They will take
And this
prompt
period,
action, Lord.
Ms. Saikia, if this guy sues the government, he was detained on 24/8. After 24/11, his detention every minute is illegal. He can sue the government for damages.
In NSA also, there was this kind of loopholes.
This
We
is
have plugged
Article
it.
27, 22(7).
Lord.
No detention beyond 3 months. This is not a rocket science. Basic fundamental of detention order. That's why when that matter came up, that was a very surprising case. The matter was filed in SB. The SB dismissed the writ petition. No argument was ever raised. But when I was skipping through the file, I asked Mr. Mazumdar, where is the order of confirmation? He was also at a loss, obviously.
We'll
So
take care, no, immediate action will be.
yes, immediate action is required. And you will pass an order in this very case. All detainees who are in jail without a confirmation order, you will issue the release order now. For the reason I'll tell you that we'll observe that every minute of detention is illegal.
Illegal.
So now this is in your knowledge.
Lordship, we may not pass that kind of order. Let Lordship give us 1 week's time, we'll rectify.
We'll ask the legal service authority to take action. That find out how many detainees are there without an order of confirmation and provide them assistance.
Lordship.
Because this is does
We
not,
will take
does
immediate
not
action.
augur well for the state's health qua the awareness of legal provisions. Okay.
Obliged, Lord.
Yes.
Highly obliged.
There is bilkul. Yes. Your writ petition is allowed.
Highly obliged.
Yes, parted. Mr. Mishra, seems you'll have to steer the ship. You're well, you're all right now. No, you just have a seat. There are other people who will be addressing.
I will.
There's one thing on which we require your assistance, guidance.
My lord.
It's a very strange thing which we have noticed in the evidence. 145 has 2 parts.
My lord.
first part, when the prosecution, without declaring the witness hostile, can draw attention to the previous statements in writing. But once the attention is drawn, whether that document can be read without it being exhibited, the same thing has happened for the defense as well as the prosecution. The statements were never exhibited in the evidence of the witness concerned.
Yes, my lord, in fact, when I was seeing that, my lord Chief Justice pointed out that it is not exhibited. On that day, Your Lordship may not have. Your Lordship, this came. I said, no, this is not exhibited. But what I was that my lord, even if it is exhibited,
That's a,
then
that's a
it is
separate
brought
thing.
on record.
This is, we are talking about
Yes.
irregularity in trial.
My lord, that,
My sister tells that in Assam, this is the general practice.
no, I have no idea. But what I remember is, my lord, I had in my initial year of practice, I had done a murder case. It was the double murder case between the two tribes of Nagaland. And I was very young and I had no guidance or anything. So I brought contradictions without exhibiting the
Statement.
161 statement. And it came up before the High Court in appeal. Out of 14, some 8 were acquitted, and for rest, I myself filed the appeal. And my lord, a great judge, my lord Justice N.M. Lahiri, as he was then, he asked me this question. And then he told me that you should have exhibited. Without that, we cannot read it.
Precisely.
That judgment is not reported, but I'll try to get. It was that time. I'm talking of somewhere in 70s, in 9, somewhere that time, 80, 79, 80. So that was that came from. So I think it was there, but may not be followed. That's a different thing.
This thing, Mr. Saab, this is falling out from 145 by itself.
Yes, yes.
You put something to the witness in the court.
Yes.
What does it literally mean? You are exhibiting it in the court.
That's right.
So without it being marked an exhibit. And then what happens is that in that exercise, they try to reproduce the entire part in the evidence. That increases the bulk.
Right.
You know, this comes to us as naturally as a child walks. Because in Rajasthan, this is a practice since ever I joined my lawyering days. And even from ever before, I would say, portion marked A to B, it will be orally read out, but while reproducing it in the text, it would be आपने अपने पूर्व बयान में भाग A से B, that A to B would be marked in the statement in red or blue ink. And that is how the exhibiting would be done. And in the evidence part, only the first 2 words and the last 2 words, and in between dots. I was just contemplating, supposing you want to confront the informant with the FIR, right? How would you do it? The FIR is exhibited.
Yes.
From the exhibit, you would do it.
Yes.
It is also a previous statement, nothing beyond that.
Yes.
Then the same current position is of 161 or 164 that matter. The second thing which really amazes me is how a 164 statement can be permitted to be exhibited in chief. It has no worth whatsoever. It's just on the same footing as 161. Previous statement recorded during investigation. Person recording it may be different. It may be on oath, doesn't make any difference. But how it can be exhibited? That's really.
My lord, I was reading the other day, the state of Rajasthan versus Kartar Singh. The judgment is by Justice Hidayatullah, my lord, his lordship was then. This is 1972 HCC. That the procedure was mentioned. What is the requirement for compliance with Section 145 of the Evidence Act? As your lordship has said, similar thing is there.
Precisely.
Without that, in fact, there, my lord, the Supreme Court has laid down that when you confront a witness with on the part that the defense wishes to contradict, then that will be in inverted comma and it will be marked. And then it is brought on record.
Yes.
But it is not, contradiction is not proved. When the IO comes and then you show.
Say that this is the statement given to you,
Yes.
then it is
Then it
finally
is
proved.
proved. The contradiction is proved.
Yes.
This is the judgment.
Yes,
my lord.
yes. I didn't get the time to make a research. That's why I'm not.
No, no, what, my lord, actually, I'm not here, but my mind is here, my lord, and I could not see, but my junior, my lord, he kept writing what your lord
No, no.
was
sorry.
deliberation, because I learned from here, my lord, I'm.
They then they don't judgment them. But you may have a seat, please. Don't exert yourself.
This paragraph 9, my lord.
That's what. It was exhibited
Well,
by the prosecutor.
Exhibited. And
Committee
then
will
also,
come-
my lord, the argument was that 145 is not complied with.
Not compliant.
That was repeated.
But we'll find judgments precisely on this issue, how it is to be exhibited. Because if that's what I was analyzing.
Hello.
145,
My lord.
it has two parts. A witness may be cross-examined as to previous statement made by him in writing
Yes, my lord.
or reduced into writing
My lord.
and relevant to matters in question, but without such writing being shown to him.
My lord.
So this is the part wherein the writing may not be shown, and that's if it is not shown, the public prosecutor reads out or the party cross-examining reads out from the document, and then it need not be exhibited. But if it is intended to contradict him by the writing, his attention must, before the writing can be proved, prove the writing.
Yes.
How the writing is to be proved then? Unless it is exhibited, it can't be proved.
Yes.
Be called to those parts which are to be used for purpose of contradicting.
Yeah.
I'll just share one of my experiences in the trial court.
My lord.
There was a matter of 376 rape. I had made extensive conferencing with the client, and he said that, sir, as a matter of fact, the girl was infatuated with me, and whatever relations we had were consensual. Then he blurted out, sir, she used to send me letters written in her blood. I said, all right, are you having them? Yes, sir, I am having. So she gave the examination in chief, everything. And then I started putting her the questions. See, you had written him the letters. She was hesitant initially. Then I said, in one of these letters, you said so. Then she broke down. She admitted everything on oral submissions. Then I told the trial judge, I will not be exhibiting them because now she has admitted everything. So that was a previous writing. So that was a situation when the witness admits the contradiction. Then it need not be proved.
Yeah.
But reduced into writing and intended to contradict, then it must be proved. How it is proved?
My lord.
Proof has to be during the statement of the witness.
My lord.
The
Absolutely.
third party can't come
Absolutely. That's the law.
because as I could analyze it, what is the import of the statement of a witness recorded by the IO in the Evidence Act, apart from it being a previous statement? To my mind, it is a hearsay.
Yes,
Hearsay. IO says
yes.
that he told me
He
so
told
and
me
so.
this and this.
So how is the IO to prove it?
Yeah.
It is a witness himself who can either admit or deny it.
Therefore, my lord, the veracity of the witnesses, whatever they have stated in chief, that has not been
Tested, that has not been contradicted. Because the part with which they were intended to be contradicted
Yes.
has not been proved.
Proved.
That is what, ask your associates to work on this 145 proved in, must be proved
My lord,
before the writing can be proved.
my lord,
So once the attention is called, that writing has to be proved.
my lord.
Please work on that. Probably
There
Mr.
is-
Chaudhary was,
There is something, if
Mr. Chaudhary was referring to some 1959 judgment.
59, yeah, I also have seen 59, 51. Yeah, 51. Tara Singh. This is Tara Singh versus State. Right? I couldn't go through, I'm passing it.
Then pass it. Where is Mr. Chaudhary, madam?
Lordship is on legs in foot number
Can't
6, Lordship, but he will be.
Can't be.
Yeah.
Parted matter going on. He has to leave all other assignments.
I have informed him.
The corollary of this discussion would be, of course, the corollary of this discussion would be what was put to the accused in 313 in relation to the testimony of those witnesses. That 161 statement exhibited by the IO. Have you tried to find out?
Well, I couldn't understand.
In relation to those statements which the trial court has relied upon by referring to the 161 statements proved by the IO.
My lord.
What is the question put in 313? Please try to examine.
I'll see.
Because the argument may come that a circumstance not put to the accused. So whether that was a circumstance put,
No.
examine 313.
I'll see 313.
Yes.
But 313, what I've seen is, it's almost a common question put to all.
Understood. But in what form the trial court has put those parts which were relied upon as substantive evidence from the 161 statements, how they have been put to the accused?
Well, subject to correction, what generally I have seen, there is no such question on 161 statement.
But then there was no argument as well.
Yes, but I see, my lord, so many things are missing this because my lord, I was
Very too bulky a case. That's right.
not only that, my lord, one of my friend, my lord, who's appearing for the other one, he has seen me. I have been appearing in this case right from bail in High Court for bail and others, and I have been saying the same thing, which here I did not take even 20 minutes. Where is the terrorist act? And my lord, again here, I would beseech your lordship to lay down law on section 17. I'll put it because under section 18, there is a law that there has to be a terrorist act in Nalini. Now 17 will also stand on the same footing.
Funding also there has to be,
Yes, and I will, my lord.
or at least a preparation for the terrorist act.
Well, like
17 would also include a preparation.
Yes.
That is the offense at par with 399.
my lord,
That preparation is also an offense.
my lord.
So that's what the question we had put to Ms. Chaudhary.
There, if some, well, my lord, there is no authentic law laid down by any court so far,
On 17.
or on 7.
There is no judgment of terror funding from Supreme Court.
No, 17, there is no, I've looked all. 18, I got this Nalini case,
Yes.
but 17, I know. Therefore, my lord, I will, when my turn comes, I will make my submission on 17 once again.
Sure.
And then I will receive whichever it is, because it will guide, my lord. There are so many cases NIA matter in the border areas.
Mhm.
That's going to help if that's done. So.
Yes, Ms. Chaudhary.
Lordship, I'm very sorry.
No, no. We are trying to have advantage of Mr. Mishra's presence.
Lordship,
Yes.
it's always Lordship.
Yes, yes.
I always tell him that Lordship, watching him argue a case is one thing, and there's a lot of
Yes.
things to learn from
You
him.
can see all these young people sitting behind. They are here to hear, witness the arguments being advanced. Yes.
Lordship. Introduction. Volume 1.
Mm.
Lordship, today I was to go into the money trade.
Yes, money trail.
For that, Lordship, first I would refer to PW 21. That your
PW
Lordship will find,
Yes.
volume 1, page 72.
Chandra Sharma. Chandra Sharma?
Chandra Sharma, Lordship.
Hmm.
Now, he is. Yes, Lordship. He is also the person who is the owner of the Tata Sumo vehicle that was apprehended on 1/4.
No. Big no. Did you put that question to him? That vehicle is registered in your name?
Question is not,
Well, how do you substantive evidence, Ms. Chaudhary?
Lordship.
How do you prove this fact? How do you prove the fact that vehicle number so and so is registered in the name of so and so? There may be n number of persons by the name of Chandra Sharma in Assam, right? But that vehicle is owned by Chandra Sharma, PW 21, would have to be stated by him because he is your witness. Had he been the accused, situation would have been different. Maybe the IO could have proved it or the DTO could have proved it.
The driver says, Lordship. Lordship. I'll take your Lordship to the
Yes.
page 72. I'm doing supply business at Haflong.
Mm.
And I have a hardware shop at Silpugri. Silpugri is in Guwahati.
All right, from this statement, it can
Yeah.
come out. He took the vehicle on Supardgi Nama. He has taken the vehicle on Supardgi Nama.
Lordship.
Yes.
And Lordship, may I read? Lordship?
Yeah, carry on. Yeah.
I know Mohit Hajai. He is in politics. We have family touch with his family. He has got a daughter studying in Guwahati and I am close to him. I have been looking after the said daughter as local guardian. On 1/4/2009, Sonam Lama telephoned me regarding taking of my vehicle on hire. He informed me that the vehicle would be used locally and may have to go outside the city. Accordingly, I gave the telephone number of Mr. Lama to my driver, Dipankar Dekka. Dipankar Dekka is the driver, Lordship. And he took the Tata Sumo out for hire. Around 1-2 p.m., my driver telephoned me and told me that he is taking the vehicle towards Shillong and I instructed him to come back soon. On the next day, my driver's wife came to me and told me that the vehicle was seized and was lying at Vasistha PS. Thereafter, I went and after doing the formalities, took the vehicle on Jimma. In 2009, Mohit Hojai telephoned me and told me to go to 80 Road And accordingly, I went to 80 Road. Exact location I have forgotten and met Imdad Ali. At that time, a person came and he met Imdad Ali and talked to him, and thereafter we both left. Again in the same year, 2009, Mohit Ojai telephoned me and told me to meet Jayanta Ghosh. Jayanta Ghosh sent a man with a packet to me, and then I took the packet and gave it to Jay. This should have been Lordship instead of Jayanta Ghosh, typographical error, Lordship, because
So who,
it would be,
how, what do we read in this place?
it has to be Mohit Ojai, Lordship.
How can we assume that?
Lordship will see.
It's a criminal trial, not a civil writ. No. We
In
can't
that case,
assume anything.
Lordship will remember yesterday's that cross. That was also typographical error, Lordship.
This we can't read in Mohit
Lordship.
Ojai here.
Lordship, I'll leave it at that. Therefore, Lordship, what I am trying to show from this, Lordship, is that this particular gentleman, Chandra Sharma, was in touch with Mohit Ojai. He knew. Now, what happens next, Lordship? I'll take your Lordship to page 148 of the same volume, Lordship. George Lamthanga. 148. Lordship has got 148. I belong to Manipur, and since 2006, I have been settling in Kolkata along with my family, consisting of my wife and 2 children. Initially, I was working as a travel agent and as well as a commission agent. Later, I was also doing the job of money exchange on commission basis through a money changer with Tapan in Kolkata. Since I was doing the job of procuring air ticket, I came to know who accused Malsa Kimi in January 2009. Since then, I used to facilitate travel tickets whenever she approached me for the same. One day in April 2008, Malsa Kimi asked me whether I have any idea about conversion of Indian rupees into dollars. At that time, I did not have any such contact, and I informed her that when I have contact, something has been left out. In June 2008, I came to know with Tapan, who is a money changer, one day when I was sitting in a roadside tea shop near New Market area. I had a 2-person discussing about conversion of US dollars, and I got introduced myself to one of the 2 persons whose name is Tapan. We exchanged our phone numbers, and since then, I used to contact him. In the month of August 2008, I informed Malsa Kimi that now I have got contact for conversion of rupees to US dollars. In the same year, same month and year, Malsa Kimi brought 15 lakhs from Aizawl for conversion to US dollars. Then I contacted Tapan and started conversion of rupee into dollars with the help of Tapan. It took about 3 days to complete the conversion. After completion of conversion, I kept my commission at a rate of 15 paisa per US dollar and returned the converted money to Malsa Kimi. In this way, she normally used to bring 15 lakhs to 20 lakh rupees for conversion to US dollars from Aizawl almost once in a month. In the month of October 2008, Masakimi brought rupees 20 lakhs for conversion to US dollars from Aizol. When I visited her at her hotel room in Center
Just
Point,
keep note of one question, Mr. Chaudhary. What is your investigation on this aspect? That where did they get this huge sum of money
Lordship,
converted? What is your
Lordship,
investigation? Like,
it will come from here, Lordship. It will come from here, Lordship. When I visit her in her hotel room at Center Point Hotel, Kolkata, to collect Indian rupees. On that occasion, I saw co-accused Vanlal Chana staying with Malsakimi at the hotel, but I did not know Vanlal Chana, and Malsakimi introduced him to me as Vantia of Aizol. After collecting the money from Malsakimi, I left the hotel and went to my rented house with the money in Kolkata. I then contacted Tapan, and as before, I exchanged the money through Tapan. It took me 3-4 days to complete the conversion. In the same way, I kept my commission at 15 paisa per so-and-so. In November 2008, Malsakimi came to Kolkata and asked me to accompany her to Madhumilan Hotel to collect the money of Vantia. And both of us went to Madhumilan Hotel at Kolkata, from where Malsakimi collected rupees 1 crore from Phojendra Hojai. Phojendra Hojai is coming in Lordship. But at that time, I did not know Phojendra Hojai. After Malsakimi collected the money, both of us headed to my rented room at Kolkata, and from where we counted the money in detail and we found rupees 1 crore. After that, Malsakimi left her hotel and I started converting the money to US dollar with the help of Tapan. It took about 10 days for converting the said money. After completion of conversion, I handed so-and-so. Again, in February 2009, Malsakimi came to Kolkata and asked me to accompany her to Madhumilan Hotel at Kolkata, from where she collected 2 crores from Phojendra Hojai. At that time, I did not know Phojendra Hojai. After receiving the money, we both of us headed to my rented house at Kolkata, and from where we counted the money in detail and found it to be 2 crores. After that, Malsakimi left for her hotel, and I started converting the money to US dollar with the help of Tapan. It took about 20 days for converting the said money. After completion of the conversion, I handed over the US dollars to Malsakimi, and in the same way, I kept my commission so-and-so. In March 2009, Malsakimi came to Kolkata and asked me to accompany her to Shalimar Hotel, where she collected 1 crore, again from Phojendra Hojai. At that time, I did not know Phojendra Hojai. After receiving the money, we both of us headed to Central Point Hotel, so-and-so, Kolkata, where Malsakimi stayed, and we counted the money in detail, found it to be 1 crore. After that, I took the money to my rented house. It took about 10 days for converting the said money. After completion of the conversion, I handed over US dollars to Malsakimi in the same way I kept my commission. Although I was accompanying Malsakimi in the said 2 hotels, I did not have any knowledge about Phojendra Hojai, from whom Malsakimi collected the money on 3 occasions. Even Malsakimi did not have any knowledge about Phojendra Hojai. I learned from Malsakimi that she was collecting the money at the behest of Vanlal Chana.
I was simply accompanying Valsa Kimi when she said that she had the money to be converted and she collected the money from a person in the hotel, in a hotel. In April 2009, May 2009, June, July 2009, Valsa Kimi brought rupees 15 lakhs from Aizol for conversion into US dollars. On each occasion, I converted the money into US dollars through Topon, and in the same way, I kept my commission after conversion. I gave the US dollars to Valsa Kimi. I did not have any knowledge about her further transaction with the money. I learned from Valsa Kimi on each occasion she had been sent by businessmen in Aizol and she was earning a commission for her job. I was arrested on 11/8/2009 by Kolkata police, and the police seized 5 lakhs from my possession, which was given to me by Valsa Kimi on 7/8/2009. But she did not tell me what to do with the money, and she said that she will let me know what to do with the money. I admit that I converted the rupees to dollars, but I am not colleague of the co-accused. I was only a commission agent working only to get a little commission to be able to maintain my family. No, Lordship, if I may take the Lordship to page 152. I have given evidence in this court on the basis of confessional statement given at the time of investigation while I was in judicial custody. It is
This is
not
a
a
very important admission.
Lordship in judicial custody. It took in 9. It is not a fact that I have given the confession statement on the threat of being tutored by the NIA officials. The person whom I referred as Topon in my evidence was arrested in Kolkata in connection with the present case. Regarding conversion of money from Indian currency to US dollars, the whole transaction was done by Topon. I do not know how much commission Valsa Kimi took for converting the Indian currency. I do not know for what purpose the aforesaid US dollars will be used by whom and for what purpose. Lordship can skip the
A very, very significant fact appearing on this page.
Lordship.
If we are to believe this witness, if at all, he says that your IU arrested Tapan and then let him go. Now what is the sanctity of your investigation? The person who was responsible for the most important act in this entire transaction, series of transactions, conversion of Indian money to US dollars. He's been let free. What is the motive of the IU now? Either we believe this statement witness as a whole or we don't believe him. So if this is to be believed, what is the sanctity of your IU's actions? Carry on. Yes.
Lordship will see the cross of Valal Chana, page 153. I could meet Valsa Kimi several occasions prior to meeting Valal Chana. I could meet Valsa Kimi in several occasions after meeting Valal Chana. Prior to also after meeting Valal Chana, I have never had any direct dealing with Valal Chana in any occasion. I could meet Valal Chana twice incidentally. Valal Chana had never
directly entrusted to exchange money to me. In the first occasion, when I could meet at Kolkata in a hotel, it is Malsa Kemi who introduced him with me. I do not know whether they occupied the same room. I've been introduced by Malsa Kemi that Vanlal Chana is a resident of Mizoram and a Mizo person. I'm not trying to implicate Vanlal Chana. In this case, I'm telling the truth. Next page, Lordship, cross for Hojendra Hojai. I have not submitted any document regarding stay at Kolkata or had doing any business in Kolkata. I do not have any license for doing the business of exchange of money. The business of exchange of money for me was an illegal business. That's why I do not have any receipt regarding the same. Prior to the identification of the accused person, first time in the court on 25/11/13, I was shown a photograph of the accused person by the NIA authority during investigation. Before 2008, I was not known to Hojendra Hojai. I did not give any description at that time of giving the statement under section 164 CRPC before magistrate, such as the color of the person, height so and so, appearance of the person whom I have identified before the court as Hojendra Hojai. I have never had any direct dealing with Hojendra Hojai. Hojendra Hojai had never directly entrusted any money to me for exchange. I never met Hojendra Hojai earlier at any occasion. I'm not trying to implicate Hojendra Hojai in this case. It is not a fact that I have never stayed at Kolkata and I have not received any money from anybody for conversion in US dollar. It is not a fact that I am trying to implicate the accused Hojendra Hojai in this case. It is not a fact that I have become approver on being pressurized in order to save myself and put the blame on other accused persons. Now, Lordship will note that page 149, the second and third paragraphs, Lordship. What is not disputed is Malsa Kemi got some money from Hojendra Hojai.
From Hojendra Hojai.
From Hojendra Hojai.
How do you know? The identification of Hojendra Hojai by this person is not reliable. You showed the photograph. He categorically says, I did not know Hojendra Hojai at that point of time.
At that point.
Now you see unnatural conduct. A person is giving crores of rupees for conversion, whether he would not ask, who is this person who is giving such a huge sum of money? That is unnatural conduct. You just ask yourself this question. You see a big money exchange going in your presence. What will be the natural human tendency?
Lordship.
To find out the identity?
Lordship.
What kind of influence Malsa Kemi had on this man that he would not even ask her, where are you getting this money from?
Lordship, the normal Lordship, market tendency, Lordship.
They are going to the place where he is.
Yes, Lordship.
They are taking the money from him in presence.
Lordship.
Would the witness not have the curiosity to ask, who is this guy? That is human curiosity. Absolutely natural human conduct. Is categoric. I did not know Hojendra Hojai at that time. So when did he get to know Hojendra Hojai? Tell us now.
It was only when the NIA showed him a photograph later on.
Does any of your witnesses say, is there an identification memo through this witness? Is there any identification memo of photograph? There is, I suppose.
Photograph is not.
Photograph identification. No? When did the NIA show show us the memo. NIA has done very ingenuity kind of exercise in this case by doing a photo identification of accused. What about this? Photo identification of Fojendra Ojai
Lordship.
by at the hands of George Lamthang. When was this exercise undertaken? He was in jail, obviously. So you will have to further show how did NIA get access to him in jail so that the photo identification could be done. Is there any document, please?
My lord, exhibit 77.
That is what the document you read.
Yes, yes.
Let us see.
Page 30, my lord. P0.
What is the date?
Date is 18/8.
2009.
2009, my lord.
Just after his arrest.
Report was in 2013.
Huh.
And this was in on 18/8/2009.
Hmm.
The identification, he was shown in the police station.
Right.
Well,
Hmm.
in presence of executive magistrate.
Right. That is what I was trying to recollect. Does it read that this identification is of photograph?
Photograph is not, he was shown, my lord. I'll place it, if lordship. Therefore, it therefore mention me, the accused George Lamthang, son of so and so, was shown a person unknown. And all Fujinder Hojai, the same person from whom he known as Fujinder Hojai, the
Yes.
same person from whom he along with Malsa Kimi had collected money from Madhu Milan and Salimar Hotel in presence of executive magistrate and independent witness at SOU police station on 18/8/2009.
All right. This memo doesn't bear the signature of Fojendra Ojai, presumably. We could not find it anywhere.
My lord,
Is it there? Please check.
my lord, I will check.
Because they can't take a plea that they would not take the signature of the accused. As George Lamthang, who is also an accused at that time, he has signed it. So why not Fojendra Ojai?
Fujinder,
Fojendra Ojai is given this, marked his, appended his signatures on some of the documents, which are quite long.
he has not. He has not.
So, Mr. Chaudhary, your witness says identification by photograph. The document says identification of a person at the police station. So this document virtually destroys your identification because the identification is based on prior identification in the police station. Even the test identification proceedings by a witness, he is an approver, by a witness fail on this ground that the accused was shown in the police station. So this argument that Fojendra Ojai was identified by George Lamthang falls flat on the face. Two grounds, contradiction and he doesn't say that the accused was shown to him. And why didn't you prove this document in his chief? If they here they have proved exhibit 77. This is exhibit. What is the exhibit? Will you let me, Mr. Counsel?
Page 30, my lord.
They will tell you, please.
77.
77.
Exhibit 77, page 30.
77 is.
No, but in his chief, you see, Mr. Mishra,
My lord.
exhibit 77 is the identification memo dated 18/8, by which I pointed out Hotel Madhu Milan and so and so. That is at page 3 of the judge witness.
There are typing mistakes. My lord. There are typing mistakes.
But in any event, in this statement, the particular document with description by which he was made to identify has not been proved. Mr. Chaudhary. You prove all sorts of identification memos of hotels, this, that,
Person is
whatever,
missing.
person. And in cross, he makes it clear that it was only through a photograph.
Lordship.
So now, how do you argue that Hossein Rozai was responsible for giving him any amount of money? Apart from the criticism that he is not reliable because he has given an exculpatory statement,
Lordship.
being an approver. Yes. You will not like to deal with that argument. Approver's evidence not being reliable because the statement is exculpatory.
That is Lordship.
That is what? You'll have to argue on reliability of the evidence, sir. You just can't go on reading the statement and say, this has proved this. There's a criticism of the evidence. How do you meet that? It's fundamental issue to be decided, that whether the evidence of the witness is reliable or not.
Lordship, since exculpatory Lordship,
You can't dispute. He says, I have nothing to do with other activities. That becomes exculpatory.
Lordship.
So what is the use of reading this statement?
Lordship.
In addition to the fact that identification of Hossein Rozai is
That was not exhibited.
to the extent of Malsakimi, maybe you can argue.
Lordship.
But money trail has to end at Hossein Rozai.
Lordship.
Continue with your trail. Let us see. Next, what would you be reading?
Volume 2. One part. May I take your Lordship to page 304?
PW.
PW is 40.
Yes, Nabajit Buragoin.
Lordship.
Witness to 77, exhibit 77.
Yes.
An assistant excise officer.
77.
Exhibit
Exhibit
77, he is a
77.
witness,
Yes.
apart from the executive magistrate.
Mhm.
That will be inadmissible.
He is also witness to the disclosure statement of Harshindra Varisa.
My lord.
Yes, yes, read.
On 13/7/2009, my superior additional deputy commissioner Kamrup so Meenal Gogoi passed a verbal order directing me to accompany NIA officials for the purpose of investigation of NIA case 1 of 2009. Accordingly, I reported at NIA office and came village so and so. From there, we can skip this paragraph, Lordship. Page 305, Lordship. On 7/8/2009, my superior additional deputy commissioner so and so passed a verbal order directing me to accompany NIA officials for the purpose of investigation of NIA case 1 of 9
Accordingly, I reported to the NIA office at Game Village, Borkhozai, Guwahati. From there, I, along with NIA officials, proceeded to Kahilipara Special Operation Unit. It is about evening hours. There I found quite a number of accused connected with this case was present. From the accused, one accused by the name of Vanlal Chana, Vantia, Joseph of Mizoram, came over and volunteered to disclose regarding his associate with lady named Sami. Thereafter, the said Vanlal Chana disclosed in Mizo language, which was recorded in Mizo by a Mizo officer who was present, and later the same was translated in English and explained to the said Vanlal Chana, who on being satisfied put his signature on the disclosure memo in my presence. The English version of the disclosure reads as, I know a lady named as Swami. She stays in Aizawl. She, along with another person, Hanga, used to convert rupees to US dollars for me to be supplied to DHDJ group 3 times. I took their help for this work. She used to go to Kolkata for this work. Her telephone number is so and so. Exhibit 118 is the disclosure memo. Exhibit 1181 is the signature of Vanlal Chana, who put his signature in my presence. Exhibit 1182 is my signature. Exhibit 1183 is the signature of Lal Sangha, who translated the Mizo version to English in my presence. Exhibit 1184 is the signature of NIA officer Santosh Kumar. On 18/8/2009, my superior, Additional Deputy Commissioner Mrinal Gogoi, passed the verbal order directing me to accompany NIA officials for the purpose of investigation of NIA case number 1 of 2009. Accordingly, I reported at NIA office at the Games Village, Borkhozai. From there, I, along with NIA officials, proceeded to Kahilipara Special Operations Unit. It was about evening hours. There I found quite a number of accused connected in this case was present. There one lady by the name of Malsakimi of Aizawl identified a person known as Hojendra Hojai, from whom she, along with Lord George Lamthang, had collected money from him from Madhumilan Hotel and Shalimar Hotel. This disclosure was made in my presence and in the presence of Executive Magistrate CP Fukal. Exhibit 119 is the identification memo. 119. 119 Lordship will find. Volume 3 of the document, exhibited documents, page
Yes.
662.
Mr. Chaudhary, tell us the law by virtue whereof we can place reliance on an identification memo of one accused by the other. Huh?
Lordship.
Is it a memo is not a substantive piece of evidence that you would agree? It's a memorandum
Lordship.
containing what the IO observed, right?
Lordship.
How is it a substantive piece of evidence? Is there any law on this issue, Mr. Mishra? That identification of one accused by another during investigation regarding admissibility of such an exercise?
maybe this is unprecedented. I have not got, but I will definitely look into.
There would be judgments on this issue.
Well, because it never happens. I
These NCB guys, they too indulge in this.
Hmm.
NCB guys, they undertake this kind of exercise.
no.
But what is the admissibility? The
One accused identifying the other accused in the police custody, and they are there together.
otherwise also, the law, even a test identification, TIP, is not a substantive piece of evidence. Going by that only. How do you prove this substantively in the court? On the same principles. TIP is not a substantive piece of evidence. Substantive identification would be in the court.
And making a declaration, my lord, I did 118, which in your lordships, you'll find it, page 42 of the exhibit. It's a declaration in the police custody, when he was in the police custody.
Yes.
The declaration he made, he was giving, and that will not go
exactly,
in
exactly.
evidence, whether PW 40 says or any witness says.
Yes. Ultimately, it is a confession.
Well, it will not. go
Whatever
in
the
evidence.
accused states in police custody, how is it admissible? In addition to the fact that it is not a, assuming that it is a document which can be read in evidence, how is it a substantive piece of evidence? No, you should not put such difficult questions.
No, no.
No, this, my lord, I can tell my lord with my experience, this hearing, everybody is going to learn. And it will be a lesson. Because it has never happened. Even when I argued for 11 days, no question was asked. I'm not trying to criticize or say, but no question was asked.
Depends on the habit of person to
Yes.
person.
So now
I
we
know,
we
I have
know
a
and-
habit of never sitting quietly,
my lord.
like
No, my lord,
an
but
idle and
that-
listening to whatever is coming.
But that educator, it educates us.
It's a mutual kind
learn.
of thing, sir. It's a mutual kind of thing.
We learn.
Yes. So now, unless there is a debate, there is no point hearing the cases.
Lordship, in fact, Lordship, very frankly, Lordship, of the record, what, it's not done properly, Lordship.
We'll not record everything. So it is of course live, but we'll not record your admissions in the judgment court.
As a counsel, I am not very satisfied.
It's pathetic, to say the least. Actually, this was the first case they were investigating, but there was nothing new. He's a police officer after all.
Well,
So this is routine investigation which was required to be done.
and IPS, my lord.
Nothing out of the ordinary in this. But a overzealousness, NIA case, so let's create identification memos of one accused to another. What is this exercise?
Perhaps, Lordship.
You ask a sub-inspector of the police whether he'll like to prepare this kind of memo.
No.
He'll say, sir, how this is to be prepared, how I will prove it in the court. He'll immediately say so.
Perhaps, Lordship, being the first case, there was more
Enthusiasm. And yes, they have succeeded in keeping the accused behind bars for 14 years. Chaliye, carry on, carry on. So this is no good. Otherwise, hit by 26.
Lordship,
Even if we don't go into that executive magistrate or judicial magistrate part, issue would be what is the substantive value of this document?
that should also have, should have been in the knowledge because it was settled just before this, this matter was taken up.
What was settled?
Whether executive magistrate.
No, forget about that. For
Judicial
assuming that it was a judicial magistrate, what is the worth of this document?
Lordship,
How can it be treated to be substantive evidence?
Lordship.
Yes,
Lordship, let us see the cross by Procedural Hotel, Lordship, at page 309.
you're again taking us to Nabajit Burgoyne.
Yes, Lordship,
Yes, cross by Fojendra Ujai.
Procedural Hotel, because
Read.
on 18/8/2009, I did not receive any written instruction from the additional deputy commissioner, Mrinal Gogoi, in connection with NIA office in relation to the investigation of this case.
I also did not maintain any record in my office in respect of my visit to the NI office. The statement in Exhibit 77 was given in Mizo language by accused George Lamthang.
He also passed away. His approval has also expired.
George Lamthang passed away.
इसमें लिखा है ना आगे, since deceased. Read at this very page.
I have read, Lordship, but
I will-
first time I'm coming.
Hmm. This is in your statement of the witness, this
Yes, yes.
practice coming. Yes.
I do not understand. I do not understand the Mizo language. The statement of the said accused was recorded by the IO in English language on being interpreted by a Mizo officer.
So there is one more thing which comes out.
Lordship.
George Lamthang was conversant only in Mizo language, right? He was not knowing English language. It's correct. What does its statement say? Is it there in his statement?
I'll try to find out, Lordship, 29. 29. Well, it was 29.
Is it anywhere on the record,
I-
Mr. Mishra,
I'll-
regarding his being conversant with what kind of language he was conversant?
I-
Is it there? Because this document creates a doubt that why there was a requirement of translation. He could have stated so in English only.
Yes.
So you please work on that.
No question, but I'll look at.
We'll just have a look at it.
Perhaps, Lordship, because George Lamthang is a Manipur.
No, border area mein hai shayad.
Yeah.
I was driving.
But then why document in Mizo and then translate it to English?
I belong to Manipur.
Now that he has stated in the
Yes.
evidence.
My lord. Rest, so he's not saying in what language.
Dialect, what was he conversant with? All right, carry on. Just take a note of this fact. What are you referring?
I was referring to Navajit.
My lord, I remember I have seen two documents, which I will just find out. He applied twice. Once for grant of pardon, then he wants to become approver. That is in English and it's written by hand.
By
Indian
hand.
written.
So then naturally he
Yes.
would be conversant.
And that he withdrew, and then second time he again filed. Both this we have, in fact, it's because of the lordship that he checked it and got we got
Mhm.
those
Okay.
papers.
First time it was a retraction.
Yes,
Oh,
my lord, I can just give this certified copy. We have just one copy.
let's see. And do we have the order? Copy of the order?
Yes, 9/11 you have given, we have given, no? I'll give my lord that. But last, while concluding my argument I had given, I'll give it again,
You had passed it on.
my
I
lord.
don't recollect. It's just-
Pardon me, yeah. Magistrate order. I think that is 9/11. 9/11 corner. Now. This is second application. The first one is that, this is second.
They know, 57.
That was first application, this is the second application.
Yes, just one moment, sir, just one moment.
9/11.
Mr. Mishra,
My lord.
these are photostat copies of the originals, right?
Yes.
These statements.
My lord.
Where does the witness sign it?
And my lord, it is there. He has seen because this is the certified copy.
Certified copy has been.
This is the
That's what we are asking you. Where has the witness signed it?
it's below.
George
he has
Langtham's-
written his name.
Read.
I don't have a copy.
No, no.
Uh-huh.
The original statement in court on oath.
Oh my. Volume 1. Volume 1. Compare that. Even 140.
This cropped up because I just wanted to verify the signatures on this application and the statement.
Yes, my lord. In the sides, if you lordship.
Sites. In our paper book, it's not there. Maybe.
Yeah, in the side.
Other paper book.
Can you pass it on,
Yes,
please?
yes,
You know?
volume 1. But I'm sorry, we don't have marked it.
No, no, it's all right. That's
Volume 1.
volume 1 देना ना. इसके अंदर नहीं होगा. ये देना. Page 29. PW?
One for.
Yeah, yes, it is there.
Yeah.
It's there.
Yeah.
Page number?
This is from 148 to
What is the page?
Page, my lord, 150.
148 to 151, lordship.
I think each page he has signed on the sides, my lord.
The signatures are same.
My lord.
There's no dispute about that.
So he may be knowing English because
Yes,
that we have.
it is a very proper application, is it?
I had passed it on. I'm giving it to your lordship, the certified copy of the pardon, which was.
That I like to see. That we would like to see. Sure. Mm. Give this application back. Keep one photostat copy here.
We don't know.
This is the order of pardon.
Yeah.
Okay, very good. Rupam, take these 3 documents, get a photostat copy done and keep it in a separate set. Yes, carry on, please.
Lordship, it come to the cross-examination by Joel Garlosa on behalf of Joel Garlosa. Lordship will find that at 311.
Mm.
There are number of assistant inspector excise in our office. I visited the NIA as well as SOU office several times during the investigation of the present case. I do not know accused Vanlal Chana from before. The investigating officers identified the accused to me. I do not know Mizo language. The accused Vanlal Chana gave his statement to the IO in Mizo language, which was recorded in English by the investigating officer in Exhibit 118.
Mm.
The accused Vanlal Chana knows English language. The statement recorded in Exhibit 118 was read over to the said accused in the language in which it was recorded. It is not a fact that accused Vanlal Chana did not give any statement to the IO.
Mm.
I did not know the accused Niranjan Hojai from before. He was also introduced to me by the investigating officer. I know Assistant Inspector of Excise, Sri Arjun Das, since he was my colleague. He works in our same office. I'm not familiar with his signature. In the statement in Exhibit 125, the accused disclosed that some articles could be recovered from the house of Bulbul Burman.
I do not know Sri Bulbul Burman. It is not a fact that the accused Niranjan Hojai neither made any disclosure statement nor led the IO to recovery of the articles. I do not know whether the house of Bulbul Burman was his own or not. I cannot remember how many rooms were there in the house of Bulbul Burman. It is not a fact that I neither visited the house of Bulbul Burman nor anything was recovered.
Yes.
Now, since Valnal Chana has been brought in, Lordship will see the cross on behalf of Valnal Chana.
Yes. What is the significant fact? You need not read every line.
Lordship.
What do you want to highlight from this cross? And why do you want to work on the cross?
Lordship, here,
What? First, tell us what this witness has proved. What is your understanding from this statement? What he has proved as per you?
Lordship, this is the mere, I would be permitting is a mere identification. Lordship.
Identification by one accused of the other. We told you what is the fate of that.
Lordship.
And you put yourself a question. It's just a step taken during investigation.
Lordship.
So there is no 27 kind of thing.
No, it's not 27.
So then it is simply a previous identification proceeding.
Lordship.
What is it worth for? You will get 100 judgments of Supreme Court. Substantive evidence, substantive identification is one which is done in the court.
Lordship. Now, Lordship, the deposit of money in the banks and taking them out.
Yes.
Sorry. Lordship, I take your Lordship to PW 31. Your Lordship will find that at page 268 in volume 2.
Ranjit Gogoi. Yes.
Because some checks were issued, Lordship, we had seen yesterday. Some checks were issued, how they were encashed and bank accounts were opened. I'm working in SBI since 29th March 2004. I was posted in Zoo Road branch, that is in Guwahati, Lordship, as branch manager since the inception of the branch, that is 3/1/2009 to 36/2009. On 26/3/2009, Devashish Bhattacharya came for opening an account in the name of Ma Trading. Ma Trading, Lordship, later on we will find that many payments were made through Ma Trading. Devashish Bhattacharya.
Is he an accused? He's a convict. He has been convicted.
Who?
Devashish Bhattacharya.
Yes. We opened the said account on 27/3/2009, taking all the necessary documents to open the said account. After opening the account the same day, Devashish Bhattacharya wanted to deposit 2 high-value checks amounting to rupees
84 lakh.
84 lakhs and 57 lakhs.
84 lakhs and 57 lakhs in the account. The checks were issued by the PHE department. PHE department, Lordship, Karuna Saikia,
Corona cycle.
remember. Issued by the PHE department, Haflong. And they also conveyed that they wanted to withdraw those amounts on the same day. But as these are very high value check and they wanted to withdraw by cash same day. So I have consulted with my senior officer, that is controller of the branch, about this. Then he suggested me to visit Haflong SBI to ascertain the genuineness of the check. Accordingly, on the next day, I personally visited Haflong SBI, and the Haflong SBI branch manager called the PHE engineer, some Mukherjee, who issued the check. Mr. Mukherjee confirmed the genuineness of the check, and he also confirmed that Mr. Debashish Bhattacharjee is a contractor of the department. On knowing those facts, I handed over those two checks to the branch manager SBI Haflong branch to credit the proceeds of those two checks to Ma Trading, account opened in our SBI Zoo Road branch. I remember that it was a Saturday, so the next working day, that is Monday, we paid an amount of rupees 84 lakhs from Ma Trading account to Debashish Bhattacharjee. And on the same day, they also withdrew a small amount of 3,50,000 for Ma Trading. While opening the account, we had little doubt about issue that the trade license submitted for account opening was originally issued 2008, but Mr. Debashish Bhattacharjee approached us for opening the account in 2009. On being asked, on asking about this, Debashish Bhattacharjee told us that he is engaged in supply contract where for day-to-day transaction account is not much necessary, as he got payment by virtue of those checks from the department. So he wanted to open the account now. Debashish Bhattacharjee also opened a current account in the name of Jeet Enterprise in the month of May 2009. I was transferred I was transferred to SBI Regional Office, Guwahati on the month. I identified said Debashish Bhattacharjee in court today, who had visited our bank for opening the account. Now, at 270, cross for Jayanta Ghosh and Debashish Bhattacharjee, Sandeep Ghosh. It is correct that SBI Zoo Road branch would have the complete record of cash transaction, both deposit as well as withdrawal. I have given only one statement under section 161 CRPC to the NIA in the present case. I know Mrs. Minu Kumari, Assistant Manager, SBI Zoo Road, Guwahati. I have worked with her for 6 months. I also know Yogendra Mohan Das, clerk so and so. I have also worked with him for about 6 months. It is correct that as a banker, we would accept a check even if it is antedated. The only criteria which we keep in mind on the date the check is presented is its validity, which was at the material time 6 months. The same facts of the date and of antedated check would also be recorded in our system maintained by us. In our statement to the NIA, I had mentioned that Mr. Diganta Vikram Gayam had accompanied Mr. Debashish Bhattacharjee to the bank, and it was Mr. Diganta Vikram Gayam who, being a smart talker, had convinced my senior to release the money immediately. It is correct that I did not make the above statements in examination in chief. On 5/2/14, I identified a signature of the observation memo, so and so. Now, this is regarding the money collected by check, deposited in the bank.
Where are the corresponding records?
These checks have been deposited. Huh?
No, the details, bank details, bank entries.
That checks are not.
Checks may have been approved, yes, but where are the bank entries? Maybe the checks might be having those endorsements.
Not.
Just find.
Chali, all right, carry on, carry on.
Find out.
There's no significant cross examination.
No, no, sir.
Yes. While we're going through the documents, the checks have those endorsements. Yes. What comes out of this? What
Lordship
comes out
has-
of this?
Lordship has noted yesterday that some checks were issued. Devashish Bhattacharjee,
Your Karuna Saikya was a different,
the
Those
reference
checks
was
were
also
to a
made-
different person,
reference
not
was-
Devashish or
No,
not the smart trading. Those checks were not issued by Karuna Saikya.
reference was also Lordship to dismiss the Mukherjee. Yesterday, Lordship.
We are talking about those checks you were referring to
Issued
about
by
Karuna
Karuna
Saikya
Saikya.
and then withdrawn by someone else.
Lordship.
The withdrawals were by who withdrew those checks? The amounts?
The two checks were issued to those 51 and 53 and
Who were the beneficiaries? Who withdrew the amounts?
they withdrew it, gave it to Mohit.
Who withdrew?
51 and 53, PW,
PW 51 and 53.
53.
So where are those corresponding bank statements?
The checks are.
Checks are given, but bank, assuming that bank records you don't give. Now you have examined the bank manager for one of those, two of these checks. What about those checks which were given by Karuna Saikya?
Karuna Saikya, Lordship, those were to Fonglo, 51 and 53.
All right.
Which we have dealt
Where are
with.
the bank entries or the bank manager statements? You have examined any more bank officials?
Lordship, the page.
All right, carry on, carry on. Do it in your way. Which next witness? Hmm.
Six. No, I'm on bank. Take your Lordship to page.
This is the very, he read just now. He just now read. This, what's the name? The Ranjit Gogoi. Just now he read. PW 31, yes.
I take your Lordship to PW 83. At page 498.
Volume
2.
$498. Yes, please. Yes, he is SBI manager. Yes.
He is also SBI manager. In the year 2009, I was posted at KEPA, branch of State Bank of India, Umrangso. Umrangso is in Dimahasa, Lordship. I was posted at that time as the assistant branch manager, remained in that branch up to March 2011. After that, I was transferred to Agartala. On 24/8/2009, pursuant to a query made by NIA, white letter dated 24/8/2009. I wrote a letter to the NIA indicating transactions in
current account standing in the name of Executive Engineer THE Umrangsu and so standing in the name of Executive Engineer THE Umrangsu respectively. 290, Exhibit 290 is the said letter written by me, and Exhibit 291 is my signature. By the aforesaid letter, I have intimated that 6 checks indicated in my letter were paid from SBI Zoo Road branch along with Zoo Road branch. Along with the letter, Exhibit 290, I have also submitted a print copy of the transaction inquiry. The payment of the 6 checks are reflected at page 23 and 24 and mentioned in serial number 2 so and so. All these checks were paid from SBI Zoo Road branch. The print copy of transaction is exhibited as 291. Lordship, Exhibit 290. In the cross, it is correct that Exhibit 290, 291, so A, B, C, and D have not been certified as per the provisions of the banker's book.
So what has he proved?
This,
The original record is not there. The certified copies are not as per the Banker's Book Evidence Act. So what is proved? Good for nothing.
Sure.
This sorry state of affairs continues. Hmm.
Right, 36, where is the page? 36. Volume 3, Lordship.
PW.
PW 94,
94.
536.
Kalyan Mukherjee. Yes. Yes. Yes.
He was the executive engineer, PHE, with additional charge of additional chief engineer during the time of CA. During the time, the CM of the council was Mohit Hojai. On my joining, I have received charge of executive engineer as well as additional chief engineer PHE as per order given by CM of NC Hills. After that, CM Mohit Hojai had given me an order to supply order in favor of Ma Trading. Lordship has come across Ma Trading supply. Ma Trading, Jeet Enterprise was also there, and Loknath Enterprise. Accordingly, I issued supply order of approximately 1.6 crore. I have received 60% of the materials approximately. The balance 40% materials not supplied by the supplier. I have given several reminders to deliver the balance materials, but the supplier failed to supply at that time. The CM's Mohit Hojai had given me pressure to release all the funds without further delay. After getting serious warning from CEM, I had complied to release the complete fund without receiving the balance 40%. I came to Guwahati after taking verbal permission from Principal Secretary due to my wife's illness. After that, the CEM Mohit Hojai called me at Hotel Pragati Manor, GS Road, that is in Guwahati, Lordship. and I met Dhruva Ghosh, Devashish Bhattacharjee. After that, executive engineer of Maibong division, Puton Namasudra, came to the hotel, and at the same time, CM Mohit Hojai directed me to issue all checks in favor of Ma Trading. He also has given assurance that the balance materials will be supplied very soon by Ma Trading. After that, one Nepalese boy who accompanied Mohit Hojai also threatened me to use the check to issue the checks as directed by the CEM, and accordingly, I had issued the checks in favor of Ma Trading. Lordship will remember a PW 5153. There was a Nepali boy who had accompanied and he came back with that amount. Here also there is a reference of a Nepali boy. The boy was accompanying Mr. Mohit Hojai. The boy who was accompanying Mohit Hojai threatened on gunpoint and told me to issue the checks. After being threatened, I got scared of my life and future, and I went back to Haflong and issued all the checks. For making up the short supply of the materials, Ma Trading issued checks to certain amounts to the supplier dealer, but since in the meantime the account was seized by the NIA, those checks could not be encashed and the materials were not received by us. Exhibit 318 under objection is a check issued in favor of Ma Trading dated 25/3/2009 for rupees 84 lakhs and odd. 318 is my signature. 319 under objection is another check in favor of Ma Trading for rupees 57 lakhs 98,000 dated 26/3/2009. 3191 is my signature. Exhibit 320 under objection is the letter dated 19/8/2009 from the DSP NIA requesting to furnish details of checks issued by Karuna Saikia and the supply orders for purchasing pipes in February, March 2009. Exhibit 321 is my signature. 321 under objection is my reply to the aforesaid letter dated 19/8/2009, giving the details of the check and the amounts in the names of the firm. 321 is my signature. 322 under objection is another letter from DSP NIA requesting to furnish certain information regarding receipt of issue of GI pipes supplied by Ma Trading. 322(1) is my signature. 323 is my reply regarding the supply order relating to Ma Trading. My exhibit 206, I have intimated the Principal Secretary NC Hills on 17/3/2009 regarding position of ARP scheme under the Maibong PHE division. Exhibit 314 is the letter dated 18/6/19 received from DSP NIA requesting to furnish information regarding receipt of materials from Ma Trading. Lordship can skip the rest. Now, Lordship will come to the cross of for Mohit Hojai. Before joining the NC Hills in the year 2009, I was posted at Tinsukia. The governor of Assam is my appointing authority. I joined in NC Hills as the executive engineer in the PHE department, but I forgot the date now. The administrative works of several departments, including my department, is being governed by the Autonomous Council of the NC Hills. Before my joining in the NC Hills, the Autonomous Council gave its no certificate, no objection. I do not know how many executive members are there in the Autonomous Council at the relevant time. My deposition in the court is in respect of the contract works given to various contractors of my department my predecessor in office in NC Hills was Karuna Saikya, but he was not available. I assumed charge. During assumption of charge due to absence, non-availability of Karuna Saikya, one executive magistrate came to our office and he first sealed all the relevant files and then handed over to me. I cannot remember the numbers of the files handed over to me on that day. The files relating to tender and supply in respect of GI pipes were handed over to me on the day of assumption of charge. I went through the files as and when required. The tender supply of GI pipes by Ma Trading, some of which were accepted earlier, were also accepted by me subsequently. Before my joining also, several tender of Ma Trading for supply of GI pipes were also accepted. And the supply order issued before my joining, I cannot say the exact amount involved in the issue of supply order in respect of GI pipes by Ma Trading. I also cannot remember the exact amount of supply order of GI pipes to Ma Trading during my tenure in office. In the month of March 2009, I remember to have issued supply of GI pipes to Ma Trading. I was called by Mohit Hojai over telephone in my personal mobile, but at present I no longer subscribe the same number and I have forgotten the number of the relevant time. I do not remember from which telephone number Mohit Hojai telephoned me on the relevant day. I came to the chief engineer office to Guwahati, but I cannot show any document to substantiate that I came to the chief engineer's office. I also cannot remember the exact date. It is not a fact that Mohit Hojai did not call me over telephone. On the relevant day, some of the bills of Ma Trading were pending. And as CEM of the Autonomous Council, Mohit Hojai directed me in the premises of Pragati Manor to clear those bills. Mohit Hojai did not threaten me. But when I came out of the room of Mohit Hojai, one unknown person threatened me, but I do not know him. I did not inform my superior authority of police.
Or police officer.
It should be or
Yes.
police officer, anything regarding the threatening received from the unknown person. This unknown person was not a member of the Autonomous Council. The intimidation given to me by the unknown person was in the form of a
We
warning.
understand, Mr. Chaudhary.
Lordship.
We understand that this witness you have examined for the purpose of showing that this was a way in which the funds were siphoned off. Okay. What happened thereafter?
Lordship.
You come to that first. Because that, as per Mr. Mishra, this is subject matter of a different trial. Is it right? Mr. Mishra, these defalcations and everything,
Yes,
they are subject matter of different trial.
my lord.
So what your objective would be to satisfy the court that these amounts reached the hands of Joel Garlosa and then they were put to use.
The finding
What
of the
they-
court is otherwise. There is a finding of the London trial court where it says about this 84 lakhs and all were in cash. And it says, but there is no evidence to show that this is the money which was recovered from A1 and in.
Obviously. That's what we are trying to ask.
In
Mr.
paragraph
Chaudhary.
419, it is very clearly.
We'll read that. Okay, we'll continue. Once after that green bench hearing is complete, we'll inform everyone and reassemble.
Lordship, Lordship, one reservation, Lordship. Should I open up before the others? Because the other
no.
accused persons are.
The other accused will hear their arguments first. But this part of your arguments has to be
Because this
completed.
relates to the others. Lordship.
No, regarding this, the money trail you complete.
That money trail, Lordship, it leads to the others. And ultimately it goes to Wanlal Chana.
No evidence.
He procures the house, it goes to the DHD.
You finish what is wrong.
No evidence.
Otherwise, even in the trial court, the case is, in the trial court, the case goes state versus so and so. You finish it off. You will get one more chance of rejoinder then.
Lordship, let them open up on that, Lordship, first.
All right. Who are the counsel representing the other accused?
Right now, I am going beyond my
Preparation.
No, no. Because I will be taken by surprise.
Who are the other council?
For K11, my lord, I am appearing, my lord, Niranjan.
Yes,
Fine.
Niranjan Ujai, all right.
Fine.
And what about Harshindra Varis Varsa?
That
Varisa?
Borgohai will do, my lord. His
Hmm?
part, Borgohai will handle it.
Borgohain will handle, okay. Babul Kempra is, okay. RH Khan, he is an important cop.
Is important.
Who is for RH Khan?
Mr. Jet Kamar will appear, my lord. Senior counsel, Mr. Jet Kamar, my lord.
He is here? Why?
Junior is there.
He is one of the,
On Tuesday, he will be available, your lordship. He's not available today, your lordship. On
Man, it's
Tuesday,
a parted matter going on.
yes, your lordship.
Then,
And tomorrow he will be there, your lordship.
so mainly we are concerned with the Valnal Chana you have done, I suppose. You argued for Valnal Chana, no? Who is there for Valnal Chana?
I'm not there.
he is not there, but he had made.
Because
some-
of 120, I made those.
Yeah, 120. Who represents Valnal Chana and Malsan Kimi?
Also, Kimi's appeal is not there, perhaps. No?
It's not there.
She has served the sentence and gone.
She has served the sentence.
She didn't even file an appeal.
No.
Oh,
She has not preferred.
okay. Niranjan Hojai,
I am appearing, my
you are appearing. So, all right, you address.
lord.
After lunch, we'll hear you.
Fine.
And Jayant Ghosh.
Jayant Ghosh is,
Huh?
Jayant Ghosh, RH Khan, lordship, they will.
Yes.
Jayanta Kumar Ghosh, Devashish Bhattacharjee and Sandeep Kumar Ghosh.
So you will be addressing.
My learned senior, Mr. Arunab Chaudhary, he will come.
So he has to be here. Tell him to be here after 2:30.
Lordship, he's an outstation counsel. He'll be here after 20th. I request your lordship. to-
No, absolutely no. Tell him to be here on Monday if at all you want an audience or address the court through BC.
Very
We
well,
are
lordship. Then-
not adjourning the matter on account of the fact that council is not there. We propose to finish off the arguments of remaining council today. You ask your senior to be either here
Lordship will
physically.
accommodate us for a VC then. I'll inform my senior.
Yes, you tell him
Address him through your lordship through VC.
whatever he wants. Yes.
Would like.
Yes.
Well, if Mr. Chaudhary will not continue with his argument, the other side, may I leave, my lord?
Definitely, definitely.
Case number Central Excise Appeal 81 of 2018.
What is the date today? 11/5. The appeal. We are of the firm opinion that substantial questions of law framed by this court while admitting the appeal deserve to be decided in favor of the SSC appellant. The impugned judgment of so and so is hereby quashed and set aside. The orders of the appellate authority and the adjudicating authority are also reversed to the extent of so and so. The appeal is disposed of in terms of the above observations and directions. There was one more. Oh,
Matter number 1.
May it please your lordship, my lord.
No, this Somoto PL has been filed regarding Milord
to clean, decontaminate and save the Horolu River. This is.
Baraulu River.
Which is one of the important tributary of river Brahmaputra. So it is highly contaminated, my lord, and the ground reality is, my lord, more than what has been written in the letter. So
So
at this
let us
stage,
put them to notice.
yes, my lord.
Let them have, after they respond or even presently, we can ask the IIT Guwahati
Yes,
to conduct an exercise of testing water of the river
yes,
from various locations,
yes.
or the pollution control board. Who do you want should be directed?
IIT Guwahati will be, my lord,
Better.
better and appropriate authority.
Do they have the means? We keep on giving them a slew of directions now and then.
To
Let us first respond to the notice, my lord.
Yes.
There is no doubt about contamination. That issue, Lordship, we fully
Yes.
undisputed, Lordship.
Yes.
Now the next stage is how to clean it and keep it clean. That is the challenge, because this river, although it was a river at one point of time, it is no more a river. It's like a
It's a stream.
bigger size of drain.
Right.
And this is the present position, Lordship. The refineries, all sewerage plus all the sewerage from all the homes are directed there. So what is to be done, Lordship? Let us,
Refinery.
because there is no dispute
which
regarding the
refinery?
contamination. Yes,
So you're
contamination.
talking of refineries.
At one point of time, yes, Lordship. Now it is totally black. I remember this is very near to my home. 30 years or maybe 35 years ago, it was white water. Now for last 20-25 years, it is all black, pitch black. So what went wrong, Lordship? Let us find it out and I'll come back to this honor.
So let's notice, issue notice, then Advocate General, Mr. Saikia puts in appearance on behalf of respondents numbers 1 and 2. Who would be appearing for GMDA?
I'm looking for 3 and 4.
3 and 4?
Not.
Mr. So and so puts in appearance on behalf of respondents number 3 and 4. And for the Pollution Control Board, you are appearing. Then Advocate General to file affidavit in reference to the contents of the suo motu petition within next 7 days.
Yes.
Preliminary affidavit.
Yes. At present, we are clearing the encroachment now. And we are also constructing guard walls. That is the process going on. But with this
Unless
monitoring-
you have a proper STP,
Exactly.
there is no use undertaking these exercises. You have to have STPs not at one place,
Several.
looking to the fact that they sooner or later you will find Brahmaputra meeting the same fate. Has anyone done the exercise of testing waters of Brahmaputra? Right from the time it originates from Arunachal, what we could see while traveling, the sewerage is going into the river. So by the time it reaches Guwahati, the extent of sewerage added into the water, we can't even imagine. So the testing of water, who is doing it? And the only means of doing it or treating the thing is to have STPs and to ensure that no part of the sewerage or the industrial effluent flows into the river.
Yeah.
Unless we undertake that exercise, it's futile to think that we can do something good for the rivers, which ultimately may be our saviors.
in fact, the STP is the part of the Guwahati master plan, my lord.
It has not been, no action on that construction of STP till date.
It is going on, Lord. See, we have it. We have, and we are having a new one. And yesterday, I think a big one has come up. Lord, I'll come back because
We'll
we are
tell you of this place. Does it have any sewerage line?
in
No.
this
This
Horolu
locality where we are right now sitting and standing. Does it have any sewerage lines? नहीं है। सब उसमें जाता stop it.
In fact, master plan also say interceptor pipeline along the Horolu River
Yes.
to just
So that
regulate the
whatever
sewage.
effluents are coming, they could be diverted to some other.
Exactly, do the sewage plan. It's there in the Guwahati master plan.
All right. Come out with
let
your
me complete.
preliminary response. We will, for once we'll have it in the next week. Lord, you just show your preliminary response.
Yes, Lord.
Then if any kind of directions are Lord, we'll follow it up. We'll re-notify on 18th May. this suo motu PI, which has been registered on the strength of a letter forwarded by Panchri Pratap Chandra Das, former student of Sonaram High School, raises a very important issue regarding the contamination and degradation of an important river of Guwahati, namely Baralu. First of all, the petitioner has highlighted in his letter that the river is, which is a tributary to Brahmaputra, to the mighty Brahmaputra, has been virtually rendered, has been severely polluted. Hazardous waste is being dumped into the river, which is causing a risk to the health and hygiene of the society. It is further alleged that none of the civic bodies entrusted with the tasks of maintaining the city's health and hygiene have bothered to put proper interventional measures on the ravaging and precarious pollution of the river. Issue notice. Then
Deeply. Matter number 2.
yes.
My lord, by this writ petition, my lord, PIL, we are challenging the decision of the Pollution Control Board Assam to give, my lord, a permission to a respondent number 4 to set up a red category industry, my lord.
Red category industry.
Yes, in spite of their own decision not to permit such an industry. If your lordship would kindly come to
Who
page
is
number 1.
respondent 4?
Respondent number 4 is a party, my lord, private party.
Okay.
Yes. If your lordship would kindly come to page
What is
1.
what precisely in the industry which
What
is
has
coming?
happened, lordship knows, there is a petroleum byproduct called, my lord, raw petroleum coke.
Petrol pet coke.
Yeah.
Yes.
Now that is being used for manufacture of, my lord, CPC, calcined petroleum coke. Now CPC is used in aluminum industry and all, my lord. Now a part of the requirement of the country is, I mean, indigenously manufactured in the refinery, and one part of it is being imported. As far as the import is concerned, the government of India, lordship knows the MC Mehta's case, the Honorable Supreme Court monitored that matter, where, my lord, import was permitted only to the extent of use in a particular industry. It can be used for the purpose of selling or something. Now, my lord, having regard to the red category, red nature of the industry, at page 130, the Pollution Control Board itself took a call, my lord.
Just hold on. Yes.
Due to pollution level caused by calcined petroleum coke and low ash metallurgical coke industry in the surrounding areas, it has been decided not to allow any further expansion of existing as well as new calcined petroleum coke and low ash metallurgical coke industry within the state of Assam. However, existing units can run their industries with all pollution control devices which are to meet the standards as stipulated by the Central Pollution Control Board.
Right.
Now, what had happened, my lord? It appears respondent number 4, initially in the year 2009, my lord. Oh, sorry, 2012. They call it, my lord, the consent to establish, CTE, was issued to them. Thereafter, they did nothing, my lord.
Okay.
Now, my lord, it appears from the impugn order, if your lordship kindly comes to 143.
Yes.
Now, kindly see, my lord. This is what we are challenging, my lord. This is on 31st of December 22.
Right.
2 mm carbon so extension of consent to establish NOC validity. Consent to establish issued by the board while later dated 10/12/12. Application dated so. This office letter number so. With reference to the above subject, the Pollution Control Board Assam hereby extends the validity period of consent to establish as referred to above for a period of 5 years with effect from the date of issue of this order, etc., etc. Now, my lord, will kindly come to that reference part, serial number 2, application number
474359.
Hmm.
My lord will kindly come to page 133. This is the
2000
application which they are referring to, page 133, my lord.
Yes, yes.
On top, lordship will right hand side will notice application number 474359.
Same number, yes.
Now kindly see the, my lord, sir. We hereby apply for consent to establish under section 2526.
Hmm.
They never, my lord, applied for extension of, my lord, their old one. In any case, my lord, what cannot be done indirectly cannot be done indirectly. Once you have taken a policy decision not to allow establishment.
Month and year of proposed commissioning of the unit
Yes,
2019.
yes. And my lord, consent to establish is something they have never taken a decision. So now where is the question of?
Where is the earlier consent you are talking of? You said that
Earlier
they got a consent.
We don't know, my lord, that
We
one.
don't.
What is the page?
It is in page number 143.
Oh,
Reference
140, sorry.
140.
Yes, my lord. Provisional consent, it was in, my lord, 10/12/2012.
Hmm. But it was the unit was never established.
No, never established.
So under this garb, your argument is that the unit not established cannot be permitted to
Yes.
be brought within the category of already existing
Yes.
units.
And if your lordship will kindly come to page 141, my lord,
Hmm.
clause 17.
141.
Yes, page 141,
Yes, please.
clause 17. The
Hmm.
consent
Shall be
to
valid for
establish
1
will
year.
be 1 year from the date of issue.
So
So
it,
it has lost its efficacy, my lord. So my humble submission is, my lord, once it is a red category industry, where is the question of permitting them, my lord? You can't do something indirectly which you can't do directly. This is your own policy to, I mean, not to encourage such a red category industry. Therefore, what I'm praying for is at this stage, my lord, they will not take any further steps pursuant to this, my lord. And in fact, my lord, my lord, one place, ma'am. Place
Yes.
131, similar prayer has been refused by the board, my. Place 131.
The Sham Carbon.
Yes.
Yes, we read.
Some carbon. It is informed with the as per board's notification, setting up of a new is not allowed within the state of Assam. Therefore, request for approval, so and so could not be accorded.
Yes,
So how can you maintain two standards?
yes. Yes,
I
please.
fully support the writ petition adopted. If this industry is a red industry and it is creating pollution in the society.
If there is no question, na?
Yes.
You yourself said it is a red industry.
Absolutely, Lordship. So now he wants that this industry should be stopped.
No, this should
One
not be
particular one.
established.
One
Not-
particular, as because he is a NGO from Delhi.
Hmm.
So my humble submission, if it is so dangerous and if it is not permissible under the pollution control norms, then all the parties, all the 7 industries in Assam, they should be made parties. And if ultimately Lordship feels that
The issue
The
here is,
issue-
short issue, just a second. Issue here is, read your notification of 2019.
I have read it.
Existing, your PCB says that existing units can run. So presently, we are not on the part whether the existing units should also be stopped or not. The scope of the petition presently is that whether any new unit can be allowed.
When it was issued in 2018, Lordship, at that point of time, the letter of consent was already given in 2012.
Read the letter of consent. That expired. They never applied for extension, sir.
Do not want anything beyond that, whatever was originally there.
Mr. Saikia, the original letter of consent had a life of 1 year. They never did under that letter,
That is-
anything under that letter. They never acted under that letter.
Did that letter, Lordship, will kindly come to page 143?
Yes, please. Read their fresh application. Do they say that extension?
December 2020.
133, please.
143.
Please read 133 first. Do they say that this is for extension
No,
of earlier one?
no.
Lordship, I am not representing them, Lordship, but
Yeah,
let me.
all right, but since you are At the one side, you are saying that you support the petitioner, and on the other side.
If it is, because his whole
So
concern is.
ifs and buts,
This
we
is
have,
an administrative, this 2018 order, for a moment.
you have refused similar permission to another industry saying that this is not permitted, this is prohibited. This is not a
because
simple.
They have come for the first time. So
Mr.
far as the
Saikia,
present one is concerned.
First time is, the present one is a fresh one, read 133. You'll understand then. They don't say that we had earlier got a consent. And then if they had got a consent, why didn't they establish it for 10 good years? Read please 133.
133. 133.
This is the application which they file. This is a fresh application. And read 134 clause 10. One
From
34.
our perspective, it is just a fresh one given. Fresh one given, but he is.
Are you supporting the
No,
the industry or-
This is a camouflage PIL. That's why I'm trying to. If
forget the
actually-
petitioner for a moment? We are on the documents
No,
which are
if
available.
that individual have to come. This is not an
We'll call the individual. Don't,
Other sevens, if they have any grievance against establishment of the eighth one.
Mr. Saikia, right now, we are simply on the application which has been.
Absolutely.
Hello.
We'll
Please
file an
read
affidavit.
that,
We'll
please.
file an affidavit, Lordship, because in our record, definitely, because if Lordship is coming to page 143,
Yes,
143.
yes, please. Please read 141
One
first.
for the extension.
Please read 141. It was not even asked for, sir. There was not even a request to extend. That is what the malified action is.
They-
They did not even pray for extension.
Let
Mr.
me
Saikia.
go to the file, Lordship.
Yes. Please come to page 141, para 17. A person gets a consent letter 10 years back, does nothing. 10 years he wakes up and says, now revive my earlier consent.
It was not
Things have
given.
changed in the intervening period.
That was in 2012. He was given.
He was given for 1 year. They don't do anything. They don't move even a single brick.
That is why, Lordship, we'll have to look into the file because what are the subsequent developments?
Saikia, for the timing, we are having the application. The application is
This
very clear.
One
It's a-
side of the story. Our side of the story, Lordship will have to.
Your
issue
side of
notice
the story, no.
and-
Side
Our
of the story of the,
Because I have to get the instructions. Today,
yes.
the matter has
So
come for
we
the
are not
first time.
saying that we are not giving you time to get instructions, but
Now, my submission is that on a greater perspective,
yes,
if they are so concerned about the pollution of the society or the atmosphere here,
they are only trying to say that act as per your own guidelines.
act-
That is what they are trying to
because
say.
our understanding is that what we have done,
Yes.
although that is why I have to look at the record where the file.
We'll
was
give you that
published.
opportunity. The party is sitting tight over the consent letter for 10 years. 10 more days would not make any difference.
Because we have given them. on
Heard
the-
learned, all right. Heard learned
Because
counsel for the-
page 143, Lordship.
Yes.
143, Lordship will kindly see extension of consent to establish NOC, reference. Consent to establish issued by the board by letter dated 10/12/2012. So there must be some process in the file. That is what I am trying to establish with it on.
We understand your attempt to defend the party, Mr. Saikia.
And we have number 3 minutes of the core technical committees held on 13/12/2022.
Yes, yes.
So what process we have done?
So yeah, all right, you come out with the process. In the meantime, we'll record our satisfaction. Don't worry.
Definitely, Lordship.
The
But my
petitioner,
humble submission, Lordship,
yes.
maybe please to implement the other parties because this is a greater public interest which they are
You indicate who are the other parties.
Yes, I have done
You
it.
file it in affidavit. You file it in an affidavit, we'll take up that matter.
If it is really they're polluting the society or the atmosphere.
Mr.
Lordship,
Saikia, from what we
everything
could
should
make
be
out
closed.
from their argument, presently they have only come out with a case that
No, if Lordship, yes, that is.
no
one
new
part.
industry can be
But
set.
if Lordship is pleased to look at all the pleadings, their whole concern is the atmosphere. The pollution in the atmosphere.
Understood, sir. It is your policy not to allow new industry of
But-
red category.
We are not allowing the ninth one. Whatever was already there in our record.
We'll take care of that argument. And you want your foreclosure of your arguments for future, we'll record it right now.
I leave it to Lordship.
Saikia, you have to draw a line somewhere. Don't try to be so partisan, sound so
No, I'm
partisan.
not partisan,
No.
but what I'm trying to
this is
say
no-
that when there is a.
Absolutely, Mr. Saikia, the document speaks for itself.
The
The document says it's a fresh permission
I have
sought.
to make my submission.
Yes, you will permit you, but don't foreclose your arguments by getting these things recorded right now. We'll leave it for later date. Land counsel for the petitioner. The petitioner has filed the instant writ petition in the nature of public interest litigation, questioning the decision of the respondent number 2, Pollution Control Board, Assam, in granting consent to set up a red category industry to the respondent number 4, red category industry, within bracket so and so, to the respondent number 4. Shri K. Chaudhary, senior advocate representing the petitioner, drew the court's attention to the notification dated 17 February 2018, issued by the Pollution Control Board Assam, wherein, it has been provided that it has been decided not to allow any further expansion of the existing as well as new calcined petroleum coke and low ash metallurgical coke industries within the state of Assam. However, the existing units have been allowed to run their industries with all pollution control devices which are to meet the standards as stipulated by the Central Pollution Control Board. Attention of the court was drawn to the order, communication dated 27 January 2022, issued by the PCB Assam to an applicant with the description of Messrs. Shyam Carbon LLP, whereby, its application to set up a new calcined petroleum coke industry was application seeking approval for setting up of new CCP unit was rejected. It was further submitted that the respondent number 4, applied for setting up of such a unit in the year 2012. The consent was granted to it for, which was valid for a period of 1 year. On 10/12/12, the consent was granted to it for a period of 1 year as per clause 17 of the letter dated 10/12/2012. The petitioner has alleged that no further action was taken by the respondent in pursuant of this consent letter, which, as per the petitioner, expired on account of inaction after 1 year. Full stop. The respondent number 4 thereafter, filed a fresh application for grant of consent on application number dated number 474359 for grant of consent to establish a CCP unit to be commissioned in the month of December 2019. The said application has been treated by the PCB Assam as a prayer for extension of consent to establish, and has been granted by letter dated 31st December 2022, which is under challenge in this PIL. We are of the prima facie opinion that the matter requires consideration because the board, having taken a decision not to allow establishment of a red category industry in Assam from 17 February 2018, cannot be allowed to change its stand at this stage. Thus, issue notice of the petition to the respondents. Then Advocate General Mr. Saikia puts in appearance on behalf of respondents numbers.
Pollution Control Board, I am appealing, all three.
1, 2, and 3. Thus, steps for service upon the respondent number 4 be taken within 3 days, whereafter process be issued to such respondent. Rule is made returnable in 2 weeks. Thus, the service is permitted till next date, comma. Status quo as it exists today shall be maintained for the industry in question.
Number 3.
Yes, in this one, what has happened?
My lord, they have today filed an affidavit, I'm sure.
It may not be in the record. We have filed it this morning. So next, on 18th, Lordship.
18th, what has been basically,
Basically,
what is the development which has taken?
basically, we have 10 forest plans. In the, 21 are pending. We have submitted the proposal to the IRO, Shillong, during the course of last 4 years.
And we had implemented that
Yes, yes, my lord. They-
IRO.
who's coming on behalf of,
Ranjit,
you are coming, all right.
And regarding two, total we have 33. 33. 10 we have, 21 it is pending at IRO Shillong for last 4 years. And 2, we are engaging some special officers to prepare and complete the special working plan, Lord. That 2 we are pending.
Okay, okay. Just a little deviation from this petition.
Lordship.
Ms. Saikia, we have observed, while I was traveling, I have observed that the government, I don't know what is the situation in Assam. In Arunachal, I saw extension plantation of Conocarpus. It seems very attractive at the outset, but its effects are disastrous. Talk to your forest officials. It has been banned in many states. It is being uprooted elsewhere where there is a ban. It draws extreme lot of groundwater. Its pollen is very harmful. It grows very fast, obviously. It becomes a jungle in no time, but its effects are disastrous, absolutely. When I was told the other day that even Guwahati has a problem of groundwater, if you start planting Conocarpus right, left and center, you will be facing such a huge shortage of groundwater. Will not be able to imagine. I was aghast when I saw the plantation in Arunachal, where there is a scope of planting any kind of indigenous plants, native plants. Why Conocarpus? Please talk to the people about, talk to the forest people. Whether this is happening in Assam, it has to be stayed restricted right away.
Lord.
It's a very dangerous thing which is happening. So, all right, we'll take their affidavit, then we'll talk further.
Lordship.
And Mr. Chaudhary? All right, Mr. Saikia submits that he has filed affidavit on behalf of the Forest Department, Assam, and appropriate steps have been taken to address the issues highlighted in the news report, on the basis whereof this suo motu PIL was registered. The affidavit be brought on record. Then at amicus curiae, Mr. Nair may file his suggestions, if so required,
Lordship.
in reference to the amendments made in the affidavit by the next date of hearing.
Lordship.
List on 18th May.
18. Much
Deeply
obliged.
Yes.
Number 4.
My lord, only with due apology, my lord. There was an affidavit reply filed by the petitioners. I have filed a counter because some certain facts were brought on record which required a counter. But my lord, unfortunately, these people are in Silchar. He was not, he's an old man, he was not keeping well.
Okay.
So my lord, I could only file it today morning, my lord. It may not.
What is the subject matter of the petition?
It's my lord with regard to setting up of a park wherein the Silchar Municipal Board had given it to us. Their case is that there was an earlier a lake in that
Lake.
area, lake, and it's a it's a green belt. I'm saying what is there. It's a green belt area. So there was a lake. So that
Which has been filled in,
no, my lord. The lake dried out long back, and that area otherwise is a commercial area. So my lord, a park is being created there, and therein there will be a commercial building wherein
inside the park.
inside the park.
The.
Amusement park,
Totally unacceptable.
amusement park,
it's not-
development of shopping mall, parking, etc. Your Lordship.
This is
In
not a-
Udaipur, there was a parking area which they put up in a park. We directed demolition.
Fine.
So we will not allow any commercial activity inside the park.
My lord, this is a commercial area.
My brother tells me that this is the only park in the locality.
Only parking.
Yes, and this is coming first on in first-hand information. So you have to be.
My lord, it was a marshy area earlier. So park, there is no park actually. There was a open space. A park is now being created, my lord.
Yes. So
Park is
let
not
the
created.
park be a park.
I'll let that also come in, my lord. We'll have it. I'll satisfy your lordship.
So argue now, what is the problem?
My lord, only thing is, the briefs came to me as well. My lord, we'll have it Monday if required, or my lord, any day. I'll satisfy your lordship.
Mr. Nair placed for time list on 18th.
18.
Item number 5,
Deeply obliged.
And my lord, this is the third round, my lord. First a title suit, then my lord, a writ petition by me, and now this.
We have not filed any title suit, Your Lord, neither writ petition. Your Lord.
May please, your lordship. My lord, here in this case, my lord, by order dated 13/9/2022. This honorable court has passed order asking the IIT Guwahati to prepare mathematical model study to approve the, my lord, the scheme, my lord, to prevent the erosion.
Yes.
And, that has been prepared and that has been also submitted by the respondent number 2 by filing an affidavit, my lord.
Okay.
So, my lord,
What has been about? 6 to 9.
It's already brought on record.
my lord,
Yes, my lord, we have filed the.
The expert committee report.
Yes, report. And in fact, my lord, as sought for by the CWC, my lord, Central Water Commission, my lord, state has complied with all requirement, my lord.
Where is the technical report of the Guwahati IIT?
Yes,
IIT
my lord,
Guwahati?
that is in the affidavit we have enclosed. Last affidavit. Okay.
Final report of mathematical model study.
Yes.
Hmm. I think we'll have to read this report first. Hmm. I think 3 days back I was reading some article. Pura village is. Hmm. I know, I read it. So maybe we'll defer it to the next week or the week thereafter. We'd like to study the file and then come back.
Yes.
Okay. 25th. List on 25th, that's great. Deep level. Yes.
May I please, your lord. My lord, appellant before your lordship is, my lord, pay 11, my lord, Niranjan Hojai, my lord.
Niranjan Hojai.
And he has been convicted by the Lahore Trial Court under section 120B, 16 and 17 and 20 of the Unlawful Activities Prevention Act, as well as 25 1 small d of the Arms Act, my lord. Here, my lord, with all respect and folded hands, my lord, the conspiracy part of it, according to prosecution case, it started in the month of 2008, November 2008, my lord. Where, my lord, I allegedly made a phone call in the phone of Dipolal Hojai that you are not fulfilling the, my lord, wishes of the people of NC Hills. So you step down. And in his place, my lord, Niranjan Hojai was, my lord, made the CEM, my lord. Yeah, my lord, that is the first conspiracy so far as I understand, my lord. And thereafter, my lord, the second part of conspiracy is the recovery of money along with arms on 1/4/2009 at Borapani, my lord.
Mm.
And in that recovery, my lord,
It's okay. The judgment, same, yes.
and in the process, my lord, they tried to entangle my appellant by putting a line or here and here, my lord, that international calls were being made when Ojendro Hozai was being apprehended, and in his mobile phone, my lord, calls from international calls came, meaning thereby that I am the person who made the said calls, my lord. Whether
From
he-
abroad,
My lord,
from abroad.
from abroad, my lord.
Okay.
That is their case, my lord. And thirdly, my lord, with all respect, my lord, my visit of PW 23 along with Mohituzai to Kuala Lumpur, where allegedly, my lord, they meet me after Mohituzai became the CEM, my lord. That is the conspiracy. It starts, my lord. So to prove that conspiracy part, my lord, regarding 26/11/2008.
Please take the trouble of reading the findings recorded by the trial court qua your accused.
On my accused, my lord.
Yes.
It starts, my lord. The lord, that lordship will find that page with all respect, my lord, 2074, my lord. That is
Paragraph.
Paragraph 303, my lord.
Yes.
According to, my lord, the learned trial court, prosecution has been able to prove these things, my lord, 2074, 303, my lord. Down below, my lord. Thus, the facts and circumstances appearing against the accused from the evidence discussed above, and which the prosecution side has been able to prove, can be recapitulated as under. In October 2003, Jewel Girls have formed one militant organization in the name of
Where does
DHD.
this discussion start from? Where does the discussion start?
My lord, it starts from, with all respect, my lord.
You just give a brief 1-2 lines from every para of discussion
My lord.
so that we can understand what the prosecution has come out with and
My lord, if I address your lordship regarding these circumstances, my lord, possibly it will cover, my lord. May I start, my lord, with all respect, my lord?
okay.
303, my lord. In 2003, Jewel Girls formed one militant organization in the name of DSDJ. He, Niranjan Ojai, was the CNC of DSDJ, and Jewel Girls was the chairman DSDJ. On 2nd of October 2009, DSDJ cadets surrendered formally, and in the aforesaid ceremony, Niranjan Ojai, the senior most DSDJ cadet, along with other cadets who led the surrender ceremony. There was a spurt of violence because of DSDJ.
Is there, can you point out this document of the surrender ceremony?
Lordship. Sure. 271, I think.
Exhibit 271.
My lord.
Read that, please. Till date, no one has referred
First
to
of
that.
all, my lord, may I please prior in one thing, my lord?
You carry on.
Lordship will find that evidence of that surrender ceremony in the evidence of PW 72, my lord. With all respect. PW 72, Anurag Tankla, the then SP of NCL.
Okay, he has proved it.
He has proved it. But lordship, interestingly, my lord, possibly his evidence cannot be taken into consideration to convict or to come to a finding that I laid arms, because no question to that effect, to the incriminating circumstance, was put to the accused while examining under 313 CRPC, my lord, by the learned trial court, my lord.
You are referring to exhibit 272.
My lord.
272 is a snatching of arms and ammunitions and the list of cases. It's not 272.
Lordship will find that the same volume, my lord, 1216. The last,
State the exhibit.
that is the exhibit, my lord. In that same volume, my lord, volume 5, my lord.
Oh, we have a separate set of relevant exhibits.
My lord.
You just tell us what is the exhibit
My lord,
marked
sorry.
on that document.
Sorry, my. 1216, my lord. Exhibit 272 by 6, my lord.
By 6,
My
okay.
lord. Exhibit volume 5, my lord.
No, they're trying to look at. An ocean of documents.
My lord. My lord.
Pages
Pages 1 to 16, my lord.
1 to 16.
Last 3 pages. Last 2 pages, my lord.
List of arms and ammunition seized.
Magazines, explosives deposited by surrender.
Understood. Where is that formal document by which the surrender was accepted? Nothing.
No. There is a video clip, my lord, exhibited, my lord. Video clip, but without 65B certificate, my lord.
All right.
That lordship will find it in the evidence of PW 70, my lord.
All right.
My lord. And furthermore, my lord, this evidence of PW 72, as I have earlier at the early point of time submitted, my lord, possibly cannot be taken into consideration because no question of this incriminating, my lord, evidence was put in 313 statement.
72.
Right.
Would you like to read the statement now or after you complete this 303?
No, I can read 72, my lord.
72 as per you is the only witness.
Who says about laying of surrender?
All right, we'll hear him. We'll consider that later.
My lord.
Yes.
Now lordship will kindly have a look, my lord. Page 303, my lord. Paragraph 303, my lord. 2075 page, my lord. These are the circumstances, my lord.
2075.
My lord. The circumstances.
Yes.
I was in serial number 4, now 5, my lord. On disclosure made by Valnansana, an identification memo was prepared, which he identified the photograph of Niranjan Ojai and Joel Garlosa. This shows his familiarity with Valnansana, the arms supplier. He was at Kuala Lumpur in February 2009, and PW Kulendra Dolagobu meets him in there. Various documents, bank accounts, including so-and-so, and credit card, Marriott Club card, which he was carrying in the name of Mrinal Rai, while staying at Nepal, concealing his real identity. It was, my lord.
Is there any document to this effect?
My lord, there is a Caesar list, my lord, and documents were exhibited. But my lord, no Caesar witness was examined. And the person who recorded the disclosure assessment, he was not even examined.
Caesar was made from this accused.
No, from the house of another accused, another person, my lord. Allegedly on disclosure made by this accused.
By this accused.
My lord.
We'll see that Caesar list.
My
Right,
lord.
carry on, carry on.
My lord. It was he under whose dictation Dipolal Ojai has submitted resignation from the post of CEM of NCHDSE. He has connection with Mohit Ojai, the then CEM of NCHSE, at whose instance the government funds meant for development of NCHSE were defalcated and channelized to DHDJ through government surveyed contractors, my lord. These are the, my lord, 9 circumstances which according to the learned trial court is proved against me, has been able to prove by prosecution against me, my lord. Now regarding, now may I go to that incident of 26/11/2008, my lord, where allegedly I made a phone call and Dipolal Ojai, the then CEM, resigned and Mohit Ojai took over as CEM, my lord.
Yes.
To prove that fact, my lord, prosecution examines PW 23, my lord.
Dipolal.
No, my lord, Kulendra Dolagopo, my lord.
Kulendra Dolagopo.
My lord.
Yes.
If lordship goes through his evidence, there is no whisper regarding these phone calls and anything, my lord. No phone calls.
So that's why we are saying
My lord.
that you read where the trial court has drawn inference regarding these incriminating circumstances in the
My lord.
judgment. Read that simultaneously.
My lord.
So that will be before these conclusions.
My lord, my lord.
Where does the trial court
My lord.
hold that these facts are proved?
My lord. My lord. Now, in PW 23, my lord, lordship will find that there is no mention about phone
I
calls.
understand. That is why you just tell us from
My
the
lord.
corresponding findings of the trial court.
And other statements that was relied upon was the hostile witnesses, my lord.
All
Hostile
right.
witnesses. Now, lordship will only have a look.
PW 81 is one witness.
He is also hostile.
He is hostile.
Man.
Oh.
PW 126, 20, 79, 81, then 82, my lord. All have become hostile.
All have been.
129 also, my lord. And the man himself, Bipola Loja, he is 126, he is also hostile.
He is hostile.
My lord.
Hmm.
Because there are series of evidence whose circumstances that has been attributed, my lord. But I prepared that, my lord, it's that from conspiracy part, my lord, regarding phone calls being made. Second, my lord, his visit to Kuala Lumpur, that lordship has also already gone. Now, whether, my lord, on 1/4/2009,
Hmm.
the appellant made a phone call in the mobile of Ojendra Ojai
Hmm.
to know that everything is going on.
Hmm.
For that, my lord, lordship will kindly have a look at paragraph 74, 75, 76, my lord,
Hmm.
of the judgment, my lord.
74, 75, 76.
My lord.
Yes.
Page 1922, my lord.
Hmm.
May I read, my lord?
Hmm.
The evidence of IO PW 146 also testified that having collected CDF from different service providers like BSNL, Airtel, following due processes as enshrined in section 65 Evidence Act, points out relevant transactions were taken and analyzed. Exhibit 4 to 5 is the scrutiny of CDR mobile number so and so, and exhibit 398, 398 by 1 to 398/7 are the CDR of mobile phone of accused Ojendra Ojai. The link analysis of CDR number so and so belonging to accused Ojendra Ojai with the service provider Airtel. Exhibit 426 is the scrutiny report and exhibit 427 is the link analysis. Exhibit 427 by 1 and 427 by 2 are the CDR of said mobile numbers. Similarly, mobile number of 9 so and so of accused Ojendra Ojai with the service provider Airtel was analyzed and printouts of
Read
relevant.
para 77. What is the point unnecessary?
My lord.
Read para
Again,
77.
my lord. Lordship will kindly have a look. But it a paragraph, my lord, with respect 77, my lord,
Yes.
77 and 70. But it appears that CDS as stated above are not collected from service providers in accordance with law and no certificate under so and so is appended thereto. There being factual provision, the same cannot be relied on in view of the judgment of the honorable so and so. The evidence of PW 150 reveals that after interception of accused Ojendra Ojai and Babul Kemprai on their way to Shillong, they were taken to police station and then accused Ojendra Ojai received calls from both Niranjan Ojai and Mohit Ojai, and the same was found recorded in mobile phones seized from accused Ojendra Ojai. It was in Dismissal language. It was translated to English language by PW 132 Joyasri Kheresa, my lord. Now lordship will have a look.
Any mobile phone was seized from
My
Niranjan
lord,
Ojai?
no, my lord. Number is not there. My lord, they say, my lord, the voice of Niranjan Ojai was collected when he gave a TV interview. That
And
voice,
with that, there was a comparison.
yes, my lord. PW 27, lordship will find, he provided the CD, my lord, of that interview that allegedly Niranjan Ojai gave. And my lord, to that IO, my lord, 150C50, my lord, he specifically said after arrest of Niranjan Ojai, his voice sample were never
Never
collected,
taken.
my lord. So this connection, my lord, on 1/4/2009, my lord, it, my lord, falls there and then only, my lord. Because no connection, my lord, they could not prove that on 1/4/2009, Niranjan Ojai made a phone call in the mobile of Ojendra Ojai. And interesting, my lord, 132, whom they used to translate the, my lord, the conversation. According to her, my lord, she says the conversation is between two persons. They say it was the conversation took place between Ojendra, Mohit, and another gentleman. My lord, making call from abroad, my lord. So PW 132, she says that, my lord, the conversation which took place, it was between two persons, my lord. The two persons, whether it is Niranjan, Mohit, that is not clear. So, my lord, that connection of 1/4/2009, that, my lord, falls there, my lord. And to this effect, my lord, in paragraph 419, my lord. 419, there is a finding, my lord, of the learned trial court, my lord. One second. One second, my lord. Paragraph 290. The 298, my lord. Sorry, my lord. Page 2073. Apparently, there is substance in the submission showed by the learned counsel of the, but here in this case, the production side, prosecution side has produced the Sony Ericsson handset seized from possession of Procedural exhibited the same as material exhibit 7, and the CD prepared from the same as material exhibit 74. So production of mobile handset as primary evidence make the position as different from the factual position in view of the observation of Honorable Supreme Court so and so. We are unable to record concurrence with the submission and discard the evidence. This is the final.
That recording is not relied upon.
Mine. So 1-4 incident goes, my lord. And regarding that, my making phone call on 26/11/2008 and making my lord Mohit, this Depola Lozai resign, that also not proved, as the rest of the witnesses are hostile, not made in accordance with law, as lordship has already my lord observed. So my lord, regarding only evidence remains is PW 23. So he does not support that, my lord. On the relevant day, he received a phone call from Niranjan. So my lord, that aspect also, my lord, that conspiracy part of it possibly not proved, my lord, could not be proved by prosecution, my lord.
All right, going ahead of that,
My lord,
the conviction is under section 17 and 20.
my lord,
What is the basis? What is the finding
my
regarding
lord,
that?
I am coming, my lord. That lordship will find us,
Finding for these offenses in this para
my lord,
300, which you were reading.
my lord,
What was that para? 303.
my lord. I am just a minute, my lord. I am coming back, my lord. My lord, 70, that is para 424, my lord. Para
This was in
424.
para 303 you were reading.
There are
Niranjan Ojai.
there are repetitions, my lord, my lord. There
You
are
read that para 303 first.
303, my lord.
Yes.
In October 2003, Jewel Galasa formed one militant organization in the name of DHDJ. He was CNC of DHDJ and Jewel Galasa was the chairman of DHDJ. He, on 2nd of October 2009, DHDJ cadre surrendered formally, and in the apostate ceremony, Niranjan Ojai was the senior most DHDJ cadres along with other cadres who led the surrender ceremony. There was a spurt of violence because of DHDJ, due to which train service flying from landing to Bodorpur was stopped. Thus, food grain going to Borak Valley, Mizoram, Tripura, and Manipur was stopped. DHDJ group had resorted to firing on moving train. This is the evidence of PW 24, my lord. This. On disclosure made by Valnan Chana, an identification memo was prepared in which he identified the photographs of Niranjan Ojai and Jewel Galota. This shows his familiarity with Valnan Chana, the arms supplier. He was at Kuala Lumpur in February 2009, and PW Kulendra Dolagu meets him there. Various documents, bank account, including Citibank, SC, Royal Tide Orchid, SC, and credit card, Marriott Club card, etc., which he was carrying in the name of Nirmal Rai while staying at Nepal, concealing his identity. It was he under whose dictation Depola Lozai submitted resignation from the post of CEM. He has connection with Mohit Ujai, the then CEM of NCHSE, at whose instance the government funds meant for development of NCHSE were defalcated and channelized to DHDJ through government subsidies, servants and contractors. So, my lord, here, my lord, I have addressed regarding that, my lord, 1/4/2009 recovery.
Hmm.
Then my lord, Niranjan Ujai making a phone call to, with all respect, my lord, Kulendra Dolakabu PW22 in the resignation of Depolal Ujai, my lord.
Hmm.
Then 2nd October ceremony, Lordship, I have already submitted that this piece of evidence,
Hmm.
incriminating piece of evidence was never put to the accused in 313, my lord. There was a spurt of violence because this is a due to his train services flying. This is the, my lord, part of material they introduced to bring it under section 15, my lord. Terror in the mind of people, my lord, because other ingredients, damaging public property by bomb, dynamite, all these things, it is completely lacking, my lord. So this piece of evidence, my lord, the terror in the mind of people, my lord,
Which who is the witness?
PW24, my lord,
24, right?
that DSP, my lord, additional SP, my lord,
Amitabh Sinha.
my lord. According to lordship, my lord, he is, my lord, more or less a hearsay because he is all
We have
evidence.
not
is-
given any conclusion. That
My
was
lord,
just
I am submitting, my lord.
a courtroom banter, you can say.
My lord,
Nothing beyond that.
That-
Don't jump to conclusions
my lord,
and don't attribute conclusions to us.
my lord, no, I am sorry, my
Conclusions
lord.
will be drawn when
My
the
lord.
judgment will come out.
My lord.
Yes.
Then, my lord, on disclosure made by Valnan Sana, an identification memo was prepared in which he identified the photographs of Niranjan Ojha and Joel Garlosa. This shows his familiarity with Valnan Sana, the arms supplier. Now, PW 40, my lord, then 52 and 148. They say the photo identification parade, my lord, I can say, my lord, it was done on a day at So police station. According to PW 40 and 52, it was done at So police station. According to 148, my lord, he said it did not take place at So police station, it took place somewhere else. My lord, in the house at Rukmini Gaon, my lord, which is 3 to 4 kilometers away from So police station, my lord. So that piece of evidence, my lord, in which, my lord, the places of occurrence of identification is not clear, my lord. Possibly it cannot also be relied upon, and it is not a substantive piece of evidence, my lord, because identification is to be made in the court, my lord.
Right.
Because these are aids in the investigation, my lord, with all respect.
Yes.
Now he was at Kuala Lumpur in February 2009. PW Kulendra Dolakbu meets him there. PW 2010, may I pray your lordship to take up 23, my lord. This is 77, volume 1, my lord. May I read, my lord? In the year 2002, I was a member of National Commission for Youth, Government of India. I resigned from that membership in 2004 and joined in active politics. I contested unsuccessfully from so and so. Again, I contested in MSc election in 2007 and won and elected to the NCL Autonomous Council. Subsequently, I was appointed an executive member in charge medical and other departments. But after resignation of Dipolal Ujai as CEM, the executive committee got defunct. In the month of November 2008, I also contested in the MP election in the year 2009, but I was defeated. I also contested in MLA election in the year 2011 by.
At best, what he says is that he met Niranjan Ojha at Kuala.
My lord, now, my lord, may I pray, my lord, the cross part of it, my lord, cross part for Niranjan and Ojha. Duel, my lord, page 80, my lord.
Yes.
In the year, lordship has gone, my lord. In the year 2009, I was member of Autonomous Council in NCL district. I hailed from so and so. My visit to Kuala Lumpur with Mohit Ujai was a personal visit. Being member of NCL's Autonomous Council during my visit to Kuala Lumpur, I did not take any permission from the government as it was personal visit. He was in public capacity, my lord, so it cannot be, my lord, personal also. Possibly permission is required.
He would not need any permission.
My lord.
Anyhow.
During my interrogation by NIA official, neither the tickets, passports were seized, my lord. That he visited, my lord, Kuala Lumpur. Regarding the activities of DSCJ, I do not have any personal knowledge, and my knowledge is confined to media as well as people. It is not a fact that I did not state before NIA that we stayed there for 2-3 days, and during the stay at Kuala Lumpur, I alone met Niranjan Ojha. Prior to my visit to Kuala Lumpur, I never met Niranjan Ojha. Before that, I was not acquainted with the physical appearance of Niranjan Ojai. It is not a fact that during my visit to Kuala Lumpur, I did not meet Niranjan Ojai. It is not a fact that my statement under 164 CRBC was made as I was asked by the NIA investigating agency. It is not a fact that I never went to Kuala Lumpur and as such my passport as well as tickets were not seized by NIA. My lord. There must have been entries, my lord, possibly in the passport that I visited, my lord, Kuala Lumpur, my lord. So this was not done, my lord.
All right.
So that part of evidence possibly also, my lord, will go in my humble submission, my lord.
Okay.
Now, next circumstance, lordship will find, my lord.
Mhm.
Various documents, bank accounts, including Citibank, SE so-and-so, credit card and etc. while he was carrying in the name of Nirmal Rai while staying at Nepal, concealing agent. It is for this, my lord, we have to go to PW 40, my lord,
40.
my lord. Volume 2.
Who is PW 29?
My lord. 29 is George Lamthang, my lord.
No, no, not 29. Just hold on. There's a person, the witness, whose statement is very long. Pranesh Parbosa, PW 30. What
PW
evidence has he given?
My lord.
PW 30.
I
what-
read, my lord. I read PW 30.
Maybe he's not connected with your accused.
No, my lord.
Just want to find out
My lord.
what is the significance of his evidence.
My lord.
It's a very long statement.
Give me a minute time, my lord.
The statement cross-examination, the complete statement runs into more than 112 pages.
My lord. My lord, he is basically, I joined social welfare department half long. Hima Asa was LDA come typist regarding defalcation on all these things.
RH Khan.
My lord.
Mostly, yes.
My lord.
Okay, okay. So now you are referring to
PW 40, my lord.
PW 40. What is the name?
Nobojit Bura Guhai, my lord.
Nawajit Borakim. I think that statement was referred by Mr. Chaudhary.
My
Yes. Yes.
PW 40, my lord. That will directly come to 308 page, my lord.
Hmm.
Page 308.
Hmm.
Second paragraph, my lord.
Hmm.
Accused Niranjan Ojai during the closure of during the course of interrogation by IO made a disclosure statement before the IO in my presence. And he also led the IO for discovery of some incriminating articles which were also recovered in my presence.
Hmm.
Exhibit 125 is the said disclosure memo and exhibit 125/1 is my signature.
Hmm.
Thereafter, the accused led us to the house of Milan Vermont, located at ward number 13, Donespara, Guwahati at about 5:30 p.m., where at the instance of accused Niranjan Ojai, a black handbag was brought out from the steel almirah from the bedroom of house of Bulbul Vermont, containing articles recovered as mentioned in exhibit 126 in my presence and 126, exhibit 126/1, exhibit 126/3 are my signatures as witness. After the recovery of the said articles, we came back to NIA office. Now these are the recoveries, my lord. Material exhibit 45 is a Thai Express Orange credit card in the name of Nirmal Rai. Material exhibit 46 is the Marriott Vacation Club Asia specific card number so-and-so in the name of Nirmal Rai.
All right, the details we'll see. What
My
is, how do you deal with this suspect?
My lord, this aspect, lordship will kindly have a look at source of case 311, my lord.
Cross-examination.
My lord.
Read.
There are number of assistant inspector excise in our, I visited the NIA as well as SO office several times in during the investigation of present case. I did not know accused Valnan Chana from before. Investigating identity accused Valnan Chana.
There is no cross by Niranjan Ojai from this witness.
Here is my lord.
There is no no cross at all. Jewel Gardens and Niranjan.
It is
There,
written
there.
like that, my lord.
Page 8. Yes, it is there.
My lord.
Yes, come.
I did
please.
not know accused Niranjan from before. He was also introduced to me by the investigator. I know assistant is Arjun Das since he was my colleague. He works in our office, same office. I am not familiar with the signature. In the statement exhibit 1 to 5 accused disclosure, some articles could be recorded from the house of Bulbul Burman. I do not know the Bulbul Burman. It is not a fact that accused Niranjan neither made any disclosure statement nor led the IO to recovery of the say. I do not know whether the house of Bulbul Burman was his own or not. I cannot remember how many rooms were there in the house of Bulbul Burman. It is not a fact that I neither visited the house of Bulbul Burman or nor anything was recovered. His signature was not exhibited.
Whose?
Niranjan. And
On the Caesar memo.
yes,
Who was the police officer or the IO who proved this document?
RK Chaudhary, my lord, as per the document, he was not even
Not examined.
my lord.
And no one else came forth for proving his signature.
No. And the other witnesses of the Caesar, my lord, they were not examined. also.
Not examined. All right.
Other witnesses, my lord.
Well, let us see the Caesar list. It is in which paper book?
It is, my lord, volume 4 of the exhibit 5, my lord. Volume 4, my lord. Page 391, my lord. Page 751, my lord. 751.
Then who would have proved the disclosure memo? RK Chaudhary was PK Chaudhary or RK
PK
Chaudhary?
Chaudhary, man. PK Chaudhary, sorry.
PK Chaudhary is not examined.
No, my lord.
So who proves the disclosure memo? then?
My lord.
There's no question of anyone else proving,
My lord.
because the contents have to be stated.
My lord. And it is to be in first person, my lord. I so and so, my lord. If my understanding is correct, my lord.
Oh, it can be in second person,
Right.
in the second person also. That's not an issue. He stated
My-
he had visited so and so.
My lord. And this was prepared in connection with NDPS case number 2. Top lordship will find, my lord.
That is all right.
My
That's all
lord.
right. But the fact discovered in one case may be proved in another case.
My lord.
But well, if the IO has not been examined,
No, my lord.
who proves the signature of the accused?
No, his signature is not proved.
Not proved.
My lord.
Please recoveries. Yes.
Now, my lord. It was under whose dictation Ripolaloza submitted resignation from the post of that I have already addressed, my lord. Now he has connection with Moiruzai, the then CEM of NCHS, at whose instance the government funds meet for developments of HESs were defalcated and channelized to DHGJ. Now here, lordship, my lord, there are 3-4 instances, my lord. One instance is of 1/4/2009. The second instance is of a seizure of money and arms at Shillong, my lord. Third instance is the subject matter of NIA case number 2, my lord, at Haflong, my lord. Zibangsu from his case was recovered.
What was cash?
Cash money, my lord, that was recovered. And my lord, that these things have been attributed to us,
Okay.
to DHDC,
Okay.
my lord. Now to prove that, my lord, with all respect,
And who has proved this statement number 2?
my lord,
He was the C of DSDJ,
my lord, primarily, my lord,
Amitabh Sinha.
Amitabh Sinha and all other evidences are of hostile witnesses. My lord.
Okay.
Those have been made hostile, my
Hmm.
lord. PW20, my lord, then 129, 126, my lord.
Okay. Okay. Yes.
My lord, this aspect, my lord, this conversion of fine, my lord, this lordship will find that with all respect, 1/4/2009, I have already addressed, my lord. There is another incident.
1/4/2009 is that Caesar
at
in Badapani.
Borapani.
Bodapani, huh?
There is no connection between Niranjan and my lord,
Jewel
Kojendra,
Gardos and yes.
my lord. This incident, my lord, that second incident, lordship will find the recovery of money, my lord,
Recovery of money,
at Shillong, my lord, on 1/5/2009.
Where is that?
61 and 62, my lord.
PW.
PW 61 and 62, my lord. They are the police officials, my lord.
From whom was the recovery effected?
Some different character, my lord.
Okay. Sixty-one and 62.
My lord.
But
May I-
this was not there. This is not there in this conclusions drawn by the trial court.
My lord, it has been discussed in some paras, my lord. I will enjoy your attention, my lord.
Okay, 61.
My lord, today I have appeared before the court on receipt of summons from the court. In the year 2009, I was posted as officer in charge Maidang Tring Police Station, East Kasivil, Shillong on 1/5/2009. My lord has got my. I got a call from so and so, Shillong, intimating me that some DSB members are coming from Juai, right towards Shillong, and she asked to come to Rani Motors, Mau Valley area. So I reached the area and found the SPCTA and her team was already there. I also found that they detained 2 persons and 1 Tata Sumo vehicle. On searching the vehicle, they have found cash of ₹50 lakhs in the vehicle, and accordingly, I made the seizure of the said amount. Hereafter, the accused along with the vehicle was taken to SP office and later on.
Who are those 2 persons? They are not
No,
before this court.
no.
But she doesn't say anything about anyhow. How we'll see how the trial court has discussed
My lord.
this evidence.
Then paragraph, then PW 62, my lord.
Mm.
In the year 2000.
Dara Singh Rongpu and Aten Haflang Bor.
My
These
lord.
are the 2 accused.
My lord.
Dara Singh was then taken in this one?
No.
One? No.
No. Accused of Haflang was given 10 days police custody, my lord. During my investigation, I recorded statement of accused person and others. During investigation, it reflected that the case of rupees so and so was seized belongs to DSDJ group, which was sent for purchase of arms at Shillong. Now cross-put, my lord. The then SP so and so verbally instructed me to take an investigation on the case, but no written instruction was given to me in connection for investigation so and so. I have not given any prayer before the concerned magistrate at the time of producing the accused persons before the honorable for recording any statement under section 164. As per the statement of arrested accused persons, I only came to know that cash of so and so which was seized belongs to DSDF, which was sent for purchase of arms at Shillong. Mau Blai area, but I had no source of any witness to prove the same belongs to DSDJ. There was no such any document along with the seized amount to show that the
All
amount
right,
belongs
all
to
right.
DSDJ.
Understood. Yes.
There is another incident, my lord, regarding recovery of cash. Recovery of money at Haflong from Jibangshu Pal, my lord. He is accused in NIA number 2. That lord
He is not an accused in this one.
not in one, my lord.
Not in one. Okay.
Accused NIA number 2. Now, for this purpose, my lord, PW lordship will have to go through PW 33 and 36, my lord.
$33. Yes.
Same volume, my lord.
Yes.
Volume 2, my lord.
Oh.
In 2009, I was working as officer in charge of Doyango Police Station, so and so. On 12/2/2009, I was working as officer in charge of Deongmu Police Station. On that, Mr. Das of Haflong Police filed an FIR at Deongmu. On receipt of FIR, I came to know that he had received some secret information and that some members of workers of were going to deliver a huge sum of money to the DSDC extremists somewhere in between Deongmu and Haflong for the purpose of procuring arms and ammunition for promoting organization activities with a view to wage war against the state. Thereafter, I registered a case being Deongmu PS case number so and so. Now, my lord, this is the recovery, madam. Now, lordship will kindly have a look that no GDNP was exhibited, my lord. Regarding that, many BSF personnel were also, my lord, present. They were not even, my lord, arrayed as we made witnesses. Now, lordship will kindly turn to PW 36, my lord. Directly come to page 290, my lord. Cross for Jivanshu Palmana. I have lost the Azhar in the instant case. In the affair, as accused persons could not give satisfactory replies for possession of amount of money seized. So I have presumed that the aforesaid money was meant and carried to hand over to the extremist organization.
Okay.
Apart from the source information, I do not have any material to show that the said money was seized on 11/2 by the exhibit 2 was meant for handing it over to the extremist organization. And the higher of the case has not made the source as a witness from whom he received information in the charge. So, my lord, it is the presumption of the investigating officer that this money was supposed to be delivered to DHD payment.
This one, this accused is also in custody.
Who, my lord?
Niranjan Ojai.
Yes, my lord. He is in jail. My lord.
3 people are there.
My lord.
Mohit, Jewel and
Niranjan,
Niranjan.
my lord. Niranjan.
Okay. What is the fate of 2/2009? Therein also there is a conviction.
My lord, there is a conviction, my lord, Jibangshu and my lord, that Karuna Soigia.
Karuna Soigia.
He died. my lord.
He has passed away.
Right.
So these persons are not accused in 2/2009.
They were discharged in 2, my lord.
They were discharged.
My lord.
Okay.
They were discharged.
So
my lord.
how many more cases wherein these 3 are in custody?
My lord, this is the only one.
This is
So
the
far-
only.
My lord, so far as I know, my lord.
Okay.
So far as I know, my lord.
We are asking only from your knowledge.
My lord, my lord.
Nothing
My
beyond that.
Now, my lord, there is a discussion, my lord, regarding the fund being used, the fund being collected, my lord, and routed to, my lord, DSDJ, 419, lord,
419
once, my lord.
of
Once,
the judgment.
judgment, my lord.
Yes.
Page 2139, my lord.
Para 419.
Incident. These facts and circumstances, lordship has got, my lord. If arranged in seriatim, the same form a chain of so complete to show complicity of all the accused persons with the charge of conspiracy to illustrate accused Mohit Ujai so and so, joined over so and so. Devashish Bhattacharya remained present at Hotel Pragati Manor in the month of March 2009 and compelled two executive engineers of PhD department NCHSE to issue checks in favor of Mart Trading, a firm registered in the name of Devashish Bhattacharya, in the name of which accused Joyanto Ghosh, Devashish Bhattacharya and Sandeep Kumar Ghosh used to do business. The checks were issued consequent to episode Pragati Manor were encased on 29/3/2009. PW 31, my lord, that my lord, my senior friend read it here today. There, my lord, on 27/3/2009, they say 84 lakhs were withdrawn. 84 lakhs were withdrawn. So these 84 lakhs, by this paragraph, my lord, they have tried to say that these 84 lakhs is the money which was given on 1/4 to Fojendra Hojai, my lord.
No, but this finding is otherwise.
Otherwise, my lord, that is why I am
Finding is other. We read
Otherwise,
that. Yes.
by opening one account in the name of so and so, and a sum of rupees 84 was withdrawn. The accused A2 and C Fojendra Hojai and Babu Kemprai were arrested on 1/4/2009 at 14 Mile Jolabad by Assam police. From their possession, rupees 1 crore, 2 pistol and so without license and 3 letterheads of DHDJ, 1 letter of CM Mohit Ujai, addressed to Superintendent Engineer PWD and RNB for awarding of contract of 87 lakhs to Fojendra were recorded, but there is no direct evidence to show that the sum carried by A1 and N2 were the same encased by Debashis Bhattacharya in the last part of month of March 2009.
Yes. That we already marked, yes.
My lord.
Okay.
Then, my lord. Fourth line from bottom, my lord. Again, official notes.
Right.
In the name of accused Mohit Ujai, A3 addresses to principal secretary so and so, so and so, so and so. In the name of farm of accused Debashis Bhattacharya and Chalans and bills in the name of some self-help groups whose existence were not found by the staff of postal department were retrieved from the hard disk and official computer of accused so and so. Accused Mohit Ujai, A3 became CM after resignation of Dipolal Ujai at the instance of accused Niranjan Ujai, my lord. This is the inference, my lord. Who is the CNC of DXCJ, my lord? Mohit Ujai has visited Kuala Lumpur along with one Kulendra who met Niranjan Ujai there. Accused Joel Golosa, A5 is the chairman of DXCJ and he was found concealing in the flat of accused Wasindo Warisa at Bangalore with the help of accused Samir Ahmed. In email of Sasindo Warisa, one email of Joel Golosa addressed to NDFB soliciting logistic supports to the cadres of DXCJ was found. Thus, all the accused are interlinked with the facts and circumstances discussed herein above. It is, however, true, there is no direct evidence to show that from accused Valnan Channa where the US dollars have gone, but it stands proof that he is an arms smuggler and at the instance huge quantity of arms and communication equipments were recovered, that is Valnan Channa's recovery, though there is absence of legal evidence to establish that procured arms and communication equipments and supplied the same to DXCJ, yet he is acquainted with accused Niranjan Ujai, the CNC DXCJ, and accused Joel Golosa, the chairman of DXCJ, and identified their photographs in a photo identification process in the presence of independent witnesses. That photo identification, my lord, episode, my lord. Now, my lord, next, thus, as held by so and so, the agreement among the conspirators can be inferred by necessary implications. It is to be noted here that all the above incriminating circumstances were put to the accused persons during their examination under section 313, but none of them have been able to account for the same satisfactorily. First of all, my lord, this is possibly, my lord, that a trial court is referring to 106 Evidence Act. First of all, my lord, prosecution has to prove, my lord, the charge against me, and only after that, my lord, my burden will come, my lord. So there is visible gaps, my lord, in the chain of circumstances, my lord, that, my lord, all these accused persons in an agreement, my lord, collected money, defalcated the same, my lord, and it was used for procuring arms and ammunition to wage war. That part already acquitted, my lord. And it comes within the purview of section 15, my lord.
Okay. Yes.
And regarding the 20.
Yes. Okay,
And
yes.
regarding the 25(1)D Arms Act, my lord, I have already, my lord, submitted that arms list by exhibited by PW 72.
There is conviction in relation to that arms list.
My lord.
Please read the finding.
My lord.
How the trial court convicts
My lord.
this accused for 25. That's absurd.
Lord. Paragraph 462, 471 my lord, of the judgment, my lord.
462.
The prosecution side relied 460 মানে accused Fojendra Ujai, Babul Kempra, Mohit Ujai, Joel Golosa, Hasindo Warisa, Valnan Channa, Malcolm Simi, Niranjan Ujai have also been charged under section so and so, provides punishment for so and so, so and so. 461. The charge against them is that after forming Dima Halim Dauga, a terrorist gang in 2004, purchased illegal arms and ammunition from the international market, particularly the Cox's Bazar of Bangladesh, and brings it to Union of India Union in contravention of Section 11 Arms Act. The prosecution side has relied upon following witnesses to establish the charge. PW 13, my lord, that Valnansana IO, my lord, that recovery from Lal Rova, my lord, house. PW 14, same, my lord, silo, my lord, to that recovery. PW 22, he becomes hostile, 20, my lord. PW 24 is the additional SP, my lord. PW 46 is the person who was allegedly, my lord, shot at by DSDJ cadres, my lord.
What does he say? Just let us-
46, my lord, lordship.
He has
my lord.
turned hostile.
No, he was not turned hostile, my lord.
What does he say? Just like
He names two different characters, my
two
lord.
different characters. he
My
names. Yes.
PW 46, my lord. Three 78 page. Volume 2, my lord, page 378.
Yes. Yeah, right.
I joined
Attacked by
DSD,
Daku Singh and alias so and so.
my lord.
Ah,
So there cannot be any vicarious liability, even if they are from DSGJ, my lord. So how can vicarious liability can be attributed to us, my
right.
lord?
Okay.
With all respected for Lenance,
And Kamarial 56.
my lord.
Yes.
PW 56.
Hmm.
Oh, my lord. I'm sorry, my lord.
You were reading para 462.
My lord, I am reading, my lord.
Hmm.
Then, my lord, Amitabh Sinha, Nairing Dullah Kapoor, my lord, he is also hostile, my lord. Harish Singh Kamial, he is a police personnel, my lord.
Hmm.
Then, my lord, 62 lordship, I have already drawn your attention that recovery at, my lord, Shillong, my lord.
Shillong.
My lord.
Okay.
Then 63 also same, my lord.
Shillong
72, my lord, that SP, my lord, who gave the list, my lord.
list.
So these are the witnesses the learned trial court relied upon.
Hmm.
And
For
finding,
25.
finding lordship will find it is para 469.
Hmm.
But other lordship, may I disturb, my lord, 467, my lord.
Yes.
The inference of this court is further fortified by the recovery of seizure of 1 crore and 3 blank letterhead of DSD Jewel and 1 letter of Mohi Ruzai from accused Fojan Ruzai on so and so. This fact makes the picture very clear. Besides, accused Valnansana has identified the photographs of Niranjan Hojai and Goyalesa in a photo identification sessions in presence of independent witness. This established the familiarity of accused Niranjan Hojai CNC, DSDJ and Joel Galdosa, chairman of DSDJ. Now 468, my lord. The evidence of PW 62 shows that in connection with case number 77/0,
Shillong.
my lord. Now 469, the factum of recovery of rupees, last line, my lord, of 468, the factum of recovery of rupees 50 lakhs cannot be ignored, being not disputed by defense side. Now, my lord, 469, thus what can be deduced from the evidence of prosecution witnesses discussed here above, it can safely be concluded that DSDJ purchased arms and ammunition from international market and bring it to India. Since they brought the arms and ammunition in contravention of Section 11 of the Arms Act, then the culpability can be fastened upon them under Section 25(1)(d) of the Arms Act. My lord.
Okay.
And the IO specifically says, my lord, that in connection with NIA 1 and 2, there has not been any recovery from any of these two persons. Recovery of arms and ammunition.
Right. That's
My lord.
okay.
My lord.
Who next? Who will be the next in line? From the defense.
My lord, I seek your lordship's liberty, my lord, if something comes up, my lord, later.
Why you have somewhere urgent to go?
No, no, my lord. If from their evidence, from their.
We will
part of
see.
my-
The hearing is continuing.
My lord.
If you have some more important work, of course. that's a
No, no, no,
different-
my lord, no, my lord.
Okay.
No, what I am submitting, my lord, if after something.
We'll give you
My-
permission to rebut if required, of course.
My lord.
Yes, who is coming now?
To be honest, man, I'm appearing for
one A4, my lord, accused appellant.
RH Khan.
RS.
He is a very important cog in this case.
It seems so, my lord, but
Allegation is at least there.
there, but nothing has been substantiated, my lord.
Then you
So
argue.
if your lordship permits me, with all respect and politeness, my lord, can I start it tomorrow, my lord?
All right, all right.
I'll
We'll
start
give you
it
that,
tomorrow.
that is. So just now recapitulate,
Yes, my lord.
Hojendra Hojai and Mohit Hojai.
My lord.
These two persons are represented by just Mr. Mishra.
My lord.
Mission.
Right.
Right.
Only two.
Two.
Vanlal Channa,
Malachanam, we are representing, my lord.
you are representing. Though Mr. Mishra has advanced
Advance,
arguments.
already advanced, my lord, nothing is left now, only a few
All right.
lines.
Who represents Babul Kemprai?
PK Kotoki, Pallab Kotoki. I'll inform him, my lord.
Okay,
Junior request.
PK Kotoki.
She is here, my lord.
Arshindo Varisa,
Arshinda was on that Burago last time.
Burgoyne.
Yes.
Okay. He has already argued. Mr. Burgoyne represents Joel Carlos.
Joel
also.
Carlos also.
And RH Khan, your good name, sir?
My Z Kamar, my lord.
Z Kamar.
Yes, my lord. Ziaul Kamar.
Okay. Vanlal Channa also you are
Yes, my lord. Along with D Talukdar, my lord.
there. Malsa Kimi,
Malskemi has not preferred an
she
appeal,
has
my
not
lord.
preferred an appeal. Okay. Niranjan Hojai,
One,
Mr. NJ Das.
This is for one, Nia one, my lord.
Of course, we are
No,
not
no,
concerned.
they-
Two is not before us. Two
No,
appeal.
they are before your lordship. Nia two
And
is
we have
also.
two appeals
Yes, yes.
for us. All right, okay. We'll consider it later.
Yes, my lord.
Jayanta
First
Kumar
one complete
Ghosh,
one, my lord.
Mr.
Yata.
Mr. Chaudhary, full name, please. Arnab Chaudhary. Devashish Bhattacharya.
Same, my lord.
12, 13, 14 also. Okay. 13 is no more.
15 is now.
Corona, my lord.
He's 13 in this case.
13 is represented.
Okay, very well.
13, I think is,
Karuna Saikia.
Corona is 15.
Read para 472 of the judgment.
Because Samir and George Langthasa have been released. That's why two is.
That's right, that's right.
Your lordship, absolutely correct.
Yes. So now the arguments which we are to hear is of Mr. Z. Kamar
Yes, my lord. Tomorrow, my
on
lord.
number 4 and 7.
7, my lord. Go ahead.
And Mr. NJ Das has concluded his arguments, subject to right of rejoinder, of course.
Sure.
No issues. That will, that there is no difficulty. And Mr. Chaudhary for 9, 10 to 13.
Yes.
All right.
11 or 7.
And we have, of course, had the expert comments of Mr. R.K. Chaudhary.
Definitely, my lord.
You have heard your expert comments, preliminary kind of thing. We'll give you opportunity.
Let it come from that.
Then he'll review it.
Okay, very well.
Otherwise, they will take the.
Opening his cards, my lord.
Okay.
It
Do you have
has-
any secrets up your
Yeah.
sleeve?
I have always been very open.
No, but in this case, whatever is there is on the record.
On the-
So what more secret?
That is why.
What other secret can you point out?
No, he's keeping
Your
his cards.
entire, Mr. Chaudhary,
Sunil,
your entire case is founded on PW 24,
one
who
way.
is absolutely hearsay, nothing else. Totally hearsay. Good news reporting.
Worship, I'll try to come up with something.
Okay, let's see.
That will be interesting.
People are queued up to hear to your argument.
Sure, my lord. बाहर कोई कर दो।